It's really a delight for me to welcome you all here to join us, to meet with us, and to engage in what may be the most well-informed conversation about probation that has occurred in many, many years. I know many of you, it's good to see old friends. We are doing this in partnership with the Robina Institute, and we appreciate their support. I especially want to express my appreciation to Bettina Munster, President Travis's staff, who has really helped us with the logistics of this thing, and Monica Whitsock, and with the arrival of Raul Rusi, we now have the greatest assemblage of former New York City probation commissioners in history. And had Vinnie Schiraldi not bailed on us, we would have the last 5 or 6 probation commissioners.
Thank you, brother. If the judges hadn't expanded so much, I would have
Yeah, he would have found us sooner.
Kevin Smiley, Marty.
I've been roaming around
Yeah,
the
he's
giant place. Where's Smiley?
This is the man who runs the Bronx, Michael. This is the man who owns the Bronx now. Anyway, so let's get started. I'm going to turn it over to Ron Corbett, who will introduce Kevin and Jeremy to kick us off.
Thanks, Marty. My name is Ron Corbett. I'm from the Robina Institute, and basically what I do is carry Marty's bag. And my assignment from the beginning, really. Thank you all for being here. This is quite a turnout, and we appreciate how busy all of you are every day. So for you to commit this kind of time for this discussion is something we appreciate deeply. I would go over the schedule, except that you have it in front of you, so I'll pass on that and simply say that we want to begin by recognizing the principals from our 2 co-sponsoring institutions and ask them to kick us off with a few words, and I will start with President Travis of John Jay.
Thank you very much, Ron, and let me also, on behalf of John Jay, welcome all of you to this discussion today. I acknowledge at the outset that Marty Horton has been a great addition to our faculty and has brought the practice world and those that teaching and policy interests to us. So we're here today in many ways because of his connection to our college. I also want to point out that he's an alumnus and his dues bill will be in the mail. While I have the microphone, I just want to say a few things by way of further introduction of the institution. And many of you are here, I know for the first time, some of you are frequent guests and visitors. We are in the room called the new courtroom, which is one of the great spaces in our new building. We're in the new building. Look that way, when the curtain is parted, you'll see a grass terrace called the Jaywalk, named by our students. It's fun with naming something. John Jay is now a senior college at the University of New York. Has meetings with those at the City University of New York. But what it basically means is that we have a full liberal arts college with a justice focus. So you'll see students here who are majoring in English, philosophy, and criminal justice, and social science, a range of topics that have some sort of connection to justice, which makes it a cool place. There are 15,000 of them. So if it looks full downstairs, you have seen some small share of 15,000. And we have over 420 or so full-time faculty, a lot of adjuncts, 3 doctoral programs, 9 master's programs, and most of those 15,000 are undergraduates. So that's the commercial advertisement that we are, and be happy to talk to you about the college more if you're interested. By way of a deeper introduction, let me just say that this conversation about probation and the role of probation in our justice system is, for me, linked to lots of other activities underway here at John Jay. So some of them you'll recognize. Marty, for example, is the executive director of the Census Commission for our state. And so that's a conversation. Socially is on that. Newton is on it. And Judge, I get your last name? Alvarado is on it.
And Professor Bushway.
And Professor Bushway used to be.
Oh, and Michael Jacobson.
You're still on it? You're still on it. Okay. My God, this is a meeting of the commission. The meeting full by now. You have to take a vote. I didn't realize that's what Marty.
I have some motions to make.
That's
So-
always trouble.
So that's one activity that's housed here. We also have the Prisoner Reentry Institute here that's doing a lot of work on reentry issues, headed up by Ann Jacobs. We have another, I handed out shamelessly, promoting something that I'm working on. This is the misdemeanor arrest report from New York State and New York City. If this interests you, we have, the team is managing this as well, the Misdemeanor Justice Project, which is looking at the phenomenon of low-level law enforcement or enforcement of low-level offenses, which, as Kevin and I were talking about today, I think is a very clear crosswalk between probation supervision and revocations and what police do. It just happen to be probation officers, but considering deprivation of liberty or enforcement of rules, that's what summonses and misdemeanors are about. Our next report that comes out in April is on, this is 33 years worth of misdemeanor arrests in New York. Our next report is on summonses, 10 years worth of summonses in New York City. Just want to go a little factoid, we issue between 500 and 600,000 summonses a year. New York, 12 to 1,600 a day. And they're all returnable to a criminal court somewhere. And guess what, most of them never quite make it. So we're trying to document that phenomenon, create this huge data set. It's lots of fun, but lots of headaches. We also have activities here that connect with this work that are related to my role as chair of the National Academy report panel on high rates of incarceration in the United States. There's been a lot of discussion here on mass incarceration, which probation is the first cousin to that phenomenon in many ways. So it feels very comfortable to be sitting here thinking about this topic, and really privileged to be thinking about this topic with me in the context of other scholarly and intellectual policy inquiries that are underway. We're here today also in partnership with Robina Institute. So I want to thank Kevin Wrights and his colleagues for coming here, and Cecilia for writing a first-rate paper that will get us going in a second. So I've watched Robina from afar, and there's a lot of cross-fertilization between the Robina Institute and other work that I and others are engaged in. So it's good to have you here in New York, and we hope that this is the first of many exchanges between John J. and Robina. For me, what is the most important big question of the day, and I'll be listening with interest to see how these experts handle it, is the question that I think stares us in the face, and we only see it from time to time in partial view, and that is, what is the role of the state today in enforcing the law, particularly as that law enforcement has become more and more intrusive and aggressive and oppressive, particularly in communities of color. That, for me, is the question of our era. And talked a lot about this, exploring in a meeting here last week on how to develop processes of racial reconciliation that would, in essence, acknowledge that our justice system has created harm. And that acknowledgement is a place to start to move out of a very difficult place that we're in. So you can take apart the justice system, look at different ways in which what we do may not be beneficial. That's, just so you know, up front, that's sort of where my head is these days, because I think that's the issue that all of us in different ways either are wrestling with or, in my view, should wrestle with, and it's the toughest one. Is what is, I just heard Michelle Alexander give an amazing talk at CUNY Theological Seminary last week. Just got my head spinning. You haven't seen it, find it on YouTube. And she frames the justice system in that context of our unresolved tension between two promises, or a promise and a fact, of all men are created equal, and Constitution still recognizes slavery. We haven't quite figured that one out yet. So the justice system sort of sits in the middle of that long historical conversation. It always has, and always will. So that, to me, becomes an issue. I'm, of course, interested also, from my National Academy perspective, in the extent to which probation and parole, revocations, are, to some extent, and I don't know the extent, feeding on levels of incarceration in different states. How do we handle that? It's a empirical question, it's a policy question, and it's an important philosophical question as to why, of course, that's the question today, should be deprived of their liberty, for what reason, for how long, by whom, and with what consequences, and why do we care about those consequences? So, big questions on the table, and I thank you for letting me sit in and listen for a while, and I'll come back and say some things at some later time. Kevin, the floor is yours, and welcome.
Well, thank you, President Travis, and thank you so much for hosting this event.
Interject, I'm sorry. I just want to make sure everybody uses the microphones because this session is recorded, and otherwise we won't be able to capture the entire discussion.
Okay.
Okay?
Well, as I was saying, my thanks to you, President Travis.
Or you can call me Jeremy. I won't accept the title. Corbett got it started. That's
I know.
He should know that.
I thought he knew best. But thanks so much for hosting this event. It's a great privilege to be here, and I have to thank Ronald Corbett as well. He's the leader of our probation project. This project has really set a tone for the other initiatives at the Robina Institute, and he is our leader and our moral center, so he's been quite a force in our young institute. The Robina Institute is fairly new. It started 3 years ago as a purely academic institute running conferences, etc., and then received additional funding to engage in multi-jurisdictional law reform projects around the country. We have 4 separately funded projects, 2 of which are under my supervision, 2 of which are headed by Richard Fraze. We're both on the law faculty at the University of Minnesota. And I should just mention, because there's so many sentencing commission members here, that 2 of the projects, not the ones that I'm in charge of, but 2 of our projects are address directly the concerns of state sentencing commissions nationwide, and including one that focuses on the use of criminal history as a sentencing factor across the state, which turns out to be a remarkably important issue that has been remarkably neglected by scholars and practitioners over the years. But I just wanted to introduce briefly this project that brings us here today, and I may say something about its sister project. The project that Ron Corbett directs focuses on probation and revocation, and everything that contributes to revocation. We see the issue of revocation as where community supervision meets prison policy. As Jeremy said, we know that revocations drive prison populations to some extent. In the parole context, BJS reports that about 30% of prison admissions annually come from parole revocations. We don't know, because BJS does not report the percentage of admissions that are coming from probation revocations, but it must be a large number. There are 4 times as many people on probation as parole nationally. Even if revocation rates are lower, there must be a significant impact on prison populations nationwide. Now, in the probation project, we work backwards from revocation. So when we go around the country and try to interest jurisdictions at the local or state level to work with us, we have a roster of potential concerns, and we try to see what they are interested in. We go back first to the number of people who are placed on probation in the first place, which is a very large number in this country. A length of term, which in some states turns out to be much, much longer than in other jurisdictions. The load of conditions, the intensity of conditions placed on probation, is how realistic they are. I didn't know I would have a soundtrack. A supervision philosophy, what happens to violations, the alternatives to a formal violations process, and then what the revocation process and outcomes look like, what alternatives there are to full revocation, and what revocation sanctions actually are. So we consider ourselves interested in all of that as contributors to the inflow eventually to the violations process, the revocations rate, and inputs into prison populations. Now, I think in the course of the afternoon, we'll probably speak a bit about all of that, and Cecilia's wonderful paper certainly brings out the strong relationship between what we do in supervision and what we do in incarceration policy in this country. But I'll just mention one thing that has really struck me in the research we've done, and just in the perspective we've gained on probation and supervision in the U.S., particularly as compared to other places in the world. We all know around this room that incarceration populations in America are the largest in the world per capita and orders of magnitude greater than places we would most like to compare ourselves to in Europe, Canada, and other English-speaking countries. And we have discovered by looking at Council of Europe data and data from other countries that the probation supervision rate in the United States is 7 times the average rate of supervision in Europe. We're 5 times the English rate, 4 times the Canadian rate, 7 times the average Australian rate of supervision. So just as the U.S. has quite a bit to think about in terms of its incarceration policy compared to other developed democracies, we are just as different. We are just as much an outlier when it comes to a supervision policy per capita, for good or ill. It's something that is very different about us that we should be aware of and think through. One consequence of this is the supervision prison interaction that we're interested in. In Europe, the combined total of parole and probation violations into the prisons accounts for 6.3% of all prison admissions, according to the most recent numbers we have, which is a tiny fraction of what must be an aggregate number close to 50% of prison admissions coming from probation and parole revocation. So we see very, very striking differences, and at least a sense of possibility that the way that we do things in this country in criminal justice may not be the only way to do things. We have a lot to learn from other places in the world, and as we'll do today, a lot to think about, a lot to talk about that has a great impact on our communities, not just in our incarceration rate, but how people live their lives in the free communities as well. So I'm looking forward to the discussion, and Cecilia's paper, I think, will spark quite a bit of conversation. So I will step back and participate in what will be a stimulating few hours.
Thank you, Kevin. Before I introduce Cecilia, I just want to acknowledge the invisible presence of 2 very important people. The 2 drivers for our probation revocation project are joining us remotely from the Rubina Institute, and I do want to mention them both. Ebony Ruland is finishing her doctoral work at the University of Minnesota in social work, and Mariel Alper is a fairly recent graduate of the doctoral program in criminology at the University of Maryland. And the truth is that they really are the key to the work that we are doing. They have made incredible investments of personal time, particularly on site, but also with their ideas and their encouragement, and I just wanted to acknowledge their presence. Professor Klingel is a wonderful friend to many of us. She's at least a double threat as I think about it. Most of us would love to be able to write with the degree of organization and clarity that she does repeatedly on difficult topics. But the second thing, which I have to say I admire even more, because I think it's unusual, is Cecilia is willing to do and has done field work for us. She is out there, boots on the ground in our jurisdictions, helping to do the research that is part of this. I know she, along a separate line, she spends a fair amount of time with the Madison Police Department. So I think that's very much to her credit, and I want to acknowledge that. So I'm happy to turn it over to her so she can help us begin to lay a foundation for our conversation.
Cecilia, can I just ask, over here. We have a lot of people who might want to know who's here, and it's hard to read these name tags, and not everyone has one. So if we could take like just 5 minutes and just starting with Sean, just do introductions, I think it would be create a sense of common purpose.
So you're very explicit about these things. What do you want us to say?
First of all, press the button.
How about name and affiliation?
Sean Bushway, University at Albany, Rockefeller College of Public Policy and Public Affairs and Policy.
Efren Alvarado, working judge, Bronx County Supreme Court criminal term.
Kevin Wright, Probation.
No. Cecilia Quindle, University of Wisconsin Law School and Revocation Institute.
Jeff Mello, professor of criminal justice, John Jay College.
Alon Yoroni?
No,
Yes. Alon Yoroni, I'm the research director for the Center of Sentencing and Corrections at the New York Institute.
Paul Rusi, CEO of the Acacia Network, one of the largest Latino-based organizations in the nation. And Marty told me everything I know.
Good afternoon, I'm Juanita Newton. I am an occasionally working judge, I guess. That's all I exactly does. I'm the dean of the Judicial Institute, and I was just this week appointed to my 4th term as a judge of the Court of Claims. By the second Mario Cuomo having been appointed, second Cuomo having been originally appointed by Mario Cuomo many years ago.
Kathy Talbert.
press the button. Press the button.
No, it has to stay up. No, just press it.
Okay.
Press it.
All right.
Press it one more time.
One more time.
There you go.
Third time's a charm. Okay. Kathy Tower Bernstein, Director, Rockland County Probation. Christelle Polsky, Director of Suffolk County Probation. Francine Broda, Deputy Commissioner of Westchester County Probation.
Rocco Posey, Commissioner of Probation in Westchester.
Gene Funicelli, Director of Probation, Putnam County.
Ana Bermudez, Commissioner of Probation, New York City.
Tina Longo, attorney in charge of the criminal practice of Legal Aid Society, New York City's primary public defender.
Hi, I'm Jeff Coots. I'm the Director of the Punishment and Public Health Project here at John Jay College.
I'm Karen Martin. I'm a professor of public management here at John Jay.
Hi, I'm Michael Jacobson. I'm a sociology professor at the CUNY Graduate Center. I'm director of the CUNY Institute of State and Local Governance.
I'm Bill Leahy. I'm the director of the New York State Office of Indigent Legal Services, and I'm a member for the Urbana Institute Advisory Board.
Marty Horn, John Jay.
Ron Corbett, project director for the Robina Institute and faculty member at the University of Massachusetts Lowell.
Shamira Gambrell, Department of Probation, New York City. Ken Yilly, Department of Probation, New York City.
Wayne McKenzie, General Counsel, Department of Probation, New York City.
Wilton Fernandez, General Counsel, Department of Probation, New York City.
Tina Munster, I'm the President's Office at John Jay College.
Sam Ayesh, President's Office, John Jay College.
Joe Rowley, Michigan Probation.
Lily Shapiro, Policy Advisor to the Commissioner, New York City Department of Probation.
Tim Sire, Assistant Commissioner, Bronx County, Department of Probation.
Greg Kushi, General Counsel's Office, New York City Department of Probation.
Sherry Silverblatt, Deputy General Counsel, New York City Department of Probation.
Sorry to be late. It's on?
Yes.
Peggy McGarry, Labour the Bureau Institute.
Okay, and now Cecilia.
And I confess to that. Okay, so I'm going to start by noticing how incredibly intimidating it is for me to be telling you anything about probation, since all of you know way more than I do about this subject. But I do want to start by thanking Kevin Wright and the Robina Institute for giving me the opportunity to do the work I've been doing after I wrote this piece a few years ago Kevin came to me and asked if I would become affiliated with the Robina Institute and described that we would have a chance to do projects that actually take ideas and try to make them work in the world. And that was one of the most exciting proposals I'd ever heard. So it took me all of 2 seconds to say yes, and I'm so glad that I have. I also want to thank my school, the University of Wisconsin Law School, which has been incredibly supportive of letting a junior professor spend a lot of time doing empirical field work, which is unusual in my world. So I'm grateful for these opportunities and to be here with you today. I want to say from the outset that I love probation. In fact, I have an agency I've worked with for many years now, and I call them, they're my probation agency. And my husband swears they supervise me. That's their main job. I believe in the power of probation, not only to transform individual lives, but also to change the conversation about the way the state interacts with its citizens in the context of criminal justice. As much as probation has dangers inherent in it and the potential for abuses, it also has the potential to change the culture of control by creating a space where state actors interact with real people in ways that can affirm their dignity and provide recognition for the fact that people are more than the crimes that they commit. I want to make sure that my work in criticizing elements of probation isn't misunderstood as an all-out attack on the nature of probation itself, but rather a criticism of the way that we're doing probation today in many places and in many ways, because so many of the structures we've created around it and the volume of the caseloads that exist in so many places impedes the ability of probation officers to engage in kind of real relationship building and change fostering that happens in the best instances of parole. So I want to thank those of you who have taken time to read my really long paper. I'm sorry, law professors are forced to write really, really long things that no one wants to read. And if you just read the abstract and include it, that's totally fine. Most of my colleagues do that too. But I was asked, just in case you were really busy and didn't have a chance to look at the piece that, again, isn't supposed to dictate our conversation in any way, but just spark a deeper conversation, I was asked to give a summary. So I'm going to try to do that in the time that I have. As you all know, most people convicted of crimes in the United States end up supervised in some way, either on probation or through post-release supervision. Today our conversation is focused on probation, but I do want to notice, as I do in my paper, that the dynamics of post-release supervision are in many places identical to those of probation and in other places greatly similar. And so what we're saying here today has broader effect than just the work of our individual agencies. Probation is usually conceived of in the US as a dichotomous choice, right? As opposed against incarceration. We treat sentencing like there really are only two options. If you're convicted, you're gonna go to jail or prison, or you're gonna get probation. And from that vantage point, for folks who are concerned about mass incarceration, and that's increasingly becoming everybody, which I think is a happy thing. From that vantage point, probation looks like the win, and incarceration looks like the lose. And that applies across the board. I think judges feel pressures when we're not dealing particularly with serious violent crimes to consider non-custodial sanctions. I definitely think defense lawyers historically have thought of anything non-custodial as an automatic win over custodial sanction. And because those who want to attack mass incarceration think they only have one choice, probation, we end up in a world where we don't examine very closely whether or not that dichotomy is a real one. And what I argue is that it's just not. Probation isn't an alternative to incarceration. It's a maybe sort of kind of, we hope, alternative to incarceration. What it is an opportunity to obtain non-custodial sanction, but it isn't one inherently. Probation is conditional release. That means it provides the legal leverage for a return to custody at any point we see a violation of a condition of supervision. It's a hope that we will not put the defendant before us in jail or prison. But when we look at the numbers, we see that that hope may be more aspirational than real, depending on the case we're dealing with. Kevin made the point that revocation rates around the country vary tremendously. So much so that it's actually very difficult to talk about average rates of return. Right? There are not a lot of studies on the subject. Most conclude that about a third of people on conditional release end up revoked. But again, we see dramatic variations jurisdiction to jurisdiction. In some places, the rate of return is actually quite low, and in others, it is over 50%. And if that's true, and incarceration, or revocation rather, then becomes a driver of incarceration, not an alternative to it. And it becomes a really subtle, is that a fire alarm? Did I just keep talking? All right, sounds good. I hope none of us burn. If in fact it's becoming a driver of incarceration, we need to examine it more closely. The ways that this happens, right? We have this goal to take someone in sentencing who we've decided doesn't need to be incarcerated and put them in the community, but then it doesn't work. We need to look at how that happens. And so there are a number of ways, and you know all of those, so I'll talk about it pretty fast. The first, again, okay, just keep going. I didn't have to, I need to be quiet anyway. All right, conditions. Okay. The number of conditions that are placed on people in most jurisdictions run longer than a page. In some cases, it can be as short as 10 to 12, though usually when you see a list that short, there's also a catch-all provision that says that not only do you have to do what the judge says, but whatever your probation officer says you should do in order to enforce the judge's order, which becomes anything the probation officer says. Okay. In other places, the formal mandatory list of sanctions set forth by the legislature are over a dozen, and then often special conditions are imposed by courts. Now, the public, of course, assumes that these are all really reasonable rules and that you have to be a pretty bad person in order to violate them, and then you do deserve to go to prison. But you all know that that's not the case at all. And while there are some conditions that really have force and connect to the criminological threats that individuals pose in our communities, there are a lot of rules that exist merely out of force of habit or bad assumptions, or in order to provide legal leverage for action in cases where probation agencies want to exercise control. The fact is, not every person who commits any kind of crime needs a no-drink condition, and yet when I look around the country, that's one of the most favorite conditions anybody has. Right? In fact, if you can commit tax evasion, that's bad, but I'm not sure it means that you can't have a glass of wine on your anniversary, right? Or that you should go to prison if you do. And we could come up with lots and lots of examples that are similar in nature. If we just had a couple conditions that were obnoxious and irrelevant, it might still be possible for individuals to comply with them as a punishment. But of course we have more than that. We have conditions on top of conditions, many of which begin to conflict with each other. So you have to have a job, it's a requirement of probation. But by the way, you have to go to counseling, and you have to go to counseling twice a week. And that's just mental health counseling, but then you also have to go to drug counseling, and you better show up at all your court appointments and your probation officer meetings, which, by the way, are across town and only during working hours. But if you lose your job because of your office, then you can't pay your probation supervision fees, and then we're going to have to revoke you. And maybe I'm being a little hyperbolic, but not too much. When we layer on top of that the amount of discretion given to individual officers and the variations we see in the culture around the enforcement of conditions that exist across the country, those sort of of extreme and hyperbolic examples of probation officers exercising power just because they can are more than sort of fears we might have in the offing. They're real cases. Real people are being used by probation in ways that are disrespectful to their basic dignity and that land them back in prison, and consequently drive incarceration rates, having the exact opposite effect from what we wanted them to have. Paper goes through at length all sorts of other different factors that can contribute to the causes of revocation, but I do want to take a second to talk about some of the ways in which agencies have tried to respond to this problem, because it's not like it's something that those of you in the field haven't noticed. One, which we've seen develop in the last decade, maybe a little longer than that, has been to try to create layers of enforcement for different kinds of conditions, right? So we all know that we've divided the world into two kinds of offenses: new crimes and technical violations. Initially, I think this was a helpful construct because it let us separate out the idea that people on probation might do things that are really bad enough to be criminalized and worthy of independent stigma and punishment. And then they might do things like miss a meeting here or there, which we think are less serious. Again, thinking about different severity of violations is helpful, but I'm not certain that trying to say the answer is to punish new crimes only, or to only lightly sanction technical violations has gotten us very far. And that's because of some of the complications, not only in the conditions themselves, but in the way that system actors interact with one another. So let me give two examples. The paper gives one of them. If we have, and I'm sorry to use such a stereotyped example, but it's the easiest to see. You have a sex offender on supervision in the community, and this is a predatory child sex offender, let's make that clear. Whether or not that person should be on probation is a different question, and the question of who's ending up on probation is an independent problem. But let's say the person's on supervision and is at a playground with no good reason. That's a technical violation. It's not a crime to go hang out on a playground as an adult. But it poses a different kind of safety threat than missing a meeting with your probation officer. And so to suggest that we should treat those two things identically because they're both technical is problematic from a legitimacy point of view. And I think that's part of the reason this dichotomy hasn't really gained a lot of traction in the field. The second example is the fact, as we know, that there are lots of new crimes that get committed and don't get charged. Sometimes they don't get charged because there is really no good basis for charging them. We'll set those aside. Other times they're not charged because there is a problem with getting a witness to comply, or there's a problem in a search. And even notwithstanding all that, we have a really solid case for believing that someone poses a threat to the community and has committed a significant new offense. It may be that a person has committed a crime and the DA's office would just love to charge it, but volume pressures in prosecution prevent them from acting. And in fact, the individual poses an immediate threat, and probation feels an obligation to act before the DA's office is going to get around to reviewing the complaint. In those cases, standard practice in many jurisdictions is for probation to use technical violations that independently would not normally prompt revocation to respond to the threat to public safety. And in that way, when we only look at numbers of technical revocations, we may be actually missing a significant subset of cases in which there was justification for the revocation fundamentally. So I don't think that the technical new crime distinction has gotten us very far. The other response that we see is attempts to limit revocation by reference to graduated sanctions grids. Graduated sanction grids, of course, have been around for a really long time, but they continue to be popular in various new iterations. And while generally the idea that we should respond with graduated, proportionate punishment to continued infractions makes sense. Many of you in this room are probably parents like me, and I think generally we all kind of do that. You escalate over time as you're not getting attention. There are many instances, particularly with individuals under supervision, who have shown themselves often to be people who don't always get the message about how to behave, where graduating your sanction isn't going to get you a better response. If someone is continually using drugs because they actually have an underlying drug addiction problem and they don't have access to treatment, you can graduate sanctions and send them to prison, but you actually haven't solved the problem at all. And it may be that there are, in fact, a lot of those sorts of fundamental problems that don't get addressed when we deal only in graduated sanctions and fail to look individually at the nature of the infraction and what's causing it. Sometimes the condition that we're enforcing we actually don't care about at all. And in those cases, graduating sanctions makes even less sense than it otherwise would. So, I don't, of course, have the solution to these intractable problems. But I do think it's helpful if we step back a little. And in thinking about how we solve some of these problems, we think not about more probation, but about less probation. And again, it would be easy to misinterpret this as I don't like probation, and please don't. But I don't think many of us in the field like probation the way it functions now, even if we truly believe in the enterprise itself. I think there are several ways we could think about less. First, we could think of less in terms of duration. As Kevin mentioned, there are many places in this country where probation goes on and on and on and on. Not for 1 or 2 years, but in fact for 10 or 20, or we're increasingly seeing lifetime supervision for some categories of offenders. If any of us were subject to the amount of rules individuals on probation are for 20 years, we would screw up, probably a lot of times. Having been in the field with officers a lot, I can tell you that I could not do the financial reporting requirements because I'm just not that organized. I actually saw an officer scold a probationer one time because when he turned in his financials, he didn't include the receipt from the Quickie Mart for the slushie that he knew he liked to get after work. I don't keep receipts very well. It doesn't work, right? We'd all violate. We would all make mistakes. If an individual, as we know from some of the good work that's been done by many of you in this room, is released from custody on the back end or from court on the front end, he or she is most likely to recidivate in the first few months and years following release. Those are the times of real vulnerability and fragility that we can connect to the underlying crime itself. After that time, if someone messes up, it's because we have some human autonomy. Right? And some people are going to decide to do something wrong some decade into the future. And often those individuals' errors are detected not by the probation officers, but by ordinary law enforcement conducting ordinary patrols. That's how those things come to the attention of authorities in the first place. It's not probation that's doing the work. Instead, it's simply exposing individuals to the possibility of revocation for minor offenses in many cases that we don't actually care about. So shortening terms of supervision to focus on the periods of time where people pose most risk seems to me to be a sensible way to use the power and resources of probation in a more targeted way that deliver public safety benefits most effectively without impinging on the autonomy and freedom of individuals who committed crimes in the past. Second, less, and this is an obvious one, is less conditions. Focus on the things we care about. If we don't put a no drink condition on you, then we can't revoke you for drinking, right? Unless your drinking escalates to the level of crime, right? And if drinking isn't really a public safety threat for you, then it shouldn't be something that gives the state power to send you to prison or to jail. Fewer conditions, more targeted, also mean that when we do enforce them, we don't have to worry so much about whether we're doing the right thing. Any condition of supervision should be a condition we're willing to revoke for and think revocation could be justified for the violation of that condition. Anything extraneous ought not to be a condition at all. And the conditions we place on individuals should be tightly tied to the risk they pose of criminal reoffending. It shouldn't be a condition that just makes their lives better, as much as we may hope that their lives improve from being on supervision, and provide resources without tying to it the threat of incarceration. Most of us don't go to the doctor and get medicine and then be told that if we don't take it regularly, the doctor's going to lock us up. Treatment for people's good shouldn't be tied to threats of incarceration. And then finally, in addition to limiting the duration of probation and limiting the conditions of probation, I do think that we need to think about limiting the situations in which we select probation as a sanction. The problem of only having two choices is a real one. Everyone in this room, and pretty much everyone in the criminal justice system, is creative enough to think in broader ways about how to punish. Again, to use the parenting analogy, because I have 8 kids, so I practice all my behavioral management control on them. Most of us punish. We don't use cages, and we're able, in many cases, to think of lots of creative ways in which to hold people accountable to achieve something positive at the same time. We can do more, and in fact, in the criminal justice system, we already have a few more options. One of them is fines or fees. Now, it doesn't get us terribly far when we're dealing with populations that may not have access to a lot of money. But that said, there are plenty of people who go on probation who aren't impoverished and for whom a financial penalty, a modest but reasonable financial penalty, may be a sufficient punishment. The other disposition, which you guys have in New York, most of the country doesn't even have this, but it makes a lot of sense, is to have unconditional discharge. A lot of judges feel like if they don't impose probation, people will think they've done nothing. But all of us who've been involved in the criminal justice system know that just charging someone and putting them through the process of being convicted is itself punitive. That's not a new insight. The process is the punishment. And especially in a world where collateral consequences are going to attach to any conviction, formal ones and informal ones, for many people who come through our system and who today receive probation, it would be better to simply say, you're convicted, you have a record, go home. That is sufficient. And then finally, there's another category of individuals, and all of you know who I mean, the ones who, as we stand in court, the judge and the defense attorney and the prosecutor all know are going to make it about 2 seconds on probation. The defendant's super happy because he or she didn't, unless the defendant has some experience, in which case he or she probably might fight probation in the first instance because they get savvy too. But the defendant may think this is great, right? I'm not going to prison or jail. And the defense attorney may say, whew, I did a great job. My client's not getting incarceration. And the DA says, whew, cleared my docket of that case, right? And the judge's like, I'm going to see you tomorrow. Probation officer feels that way even more. They're individuals who are not good candidates for conditional release. We know they can't comply with the conditions they're being put to. We need to be honest about those cases. Not everyone is meant for probation. And we don't do ourselves any real favors by feeling good for a minute in the courtroom and then sending the individual later, outside the transparency of court, back to jail or prison. We perpetuate the problem. And for those individuals, a very, very short, modest custodial sanction, I think, is often a much better decision than the constant churning of conditional release terms that are revoked and reinstated, and revoked and reinstated. Some of the mentors call this doing life on the installment plan. Right? We see that especially with post-release supervision. So I think that those are just opening thoughts. You can tell me they're all wrong, and I'd be grateful to learn from you. But I hope that it opens up a conversation where you can share your insights about what the future of probation might be. Thanks.
Thank you, Cecilia. I think you've given us quite a lot to think and talk about. So now we're going to open it up for crosstalk and dialogue. We've asked Kevin and Jeremy to start us off, and after their initial remarks, we're happy to have have the rest of you jump in. Kevin, do you want to start us off?
Sure. Cecilia, you know I think very highly of this paper, and it certainly influenced my thinking. But to have a sense of the proper scale of community supervision, well, let me put it this way. In this country, I think we're having a very robust conversation right now. Who needs to be in prison? When do we need to make use of incarceration? And presumably, if we think we should make less use of it, who shouldn't be incarcerated? And if one of the insights of your paper is we need to be asking the same questions about probation, how do you make an affirmative case for who should be on probation? I think you've identified in your talk some categories where something other than a remedy other than probation might make sense. But what's the affirmative case if we're moving towards a new equilibrium, or if we should be moving towards a new equilibrium with a smaller standing supervision population? Who is it that should be, within that class or within that category?
So I think that the people who most benefit from community supervision, first of all, and I know Ron disagrees with me on this, others will too, I'm sure. First of all, I don't think people should go on probation unless we actually believe that they deserve it, or that a term of custody would not be undeserved for them based on their underlying criminal conduct. Because probation is conditional release, it always carries with it that possibility of revocation. So I think, first of all, we have to start with a class of people who we think might deserve to go to prison, but for some reason, we're going to choose not to send them there. And I say prison, but I mean prison or jail, right? Because we should be thinking in much shorter terms of custody as well as shorter terms of probation. But we're not going to do that because we believe there's something about remaining in the community that's helpful. And the most obvious thing, of course, is that for almost everyone, prison only makes life worse. So we might want to shield them from the teratogenic effects of incarceration. But in addition, I think that often we're dealing with individuals who we think are amenable to supervision and to engagement, who will do what they need to do to get their lives back on track, but need help ordering their lives, and who need someone checking in with them regularly and pointing them to resources and providing what are effectively social services with the lurking threat of state control behind it, in order to make that break from more criminal activity and instead get integrated into a pro-social life.
Jeremy?
I've already learned a lot, and thank you for the very thought-provoking and very wonderfully clear, as Ron promised, presentation of the paper. So I have just 1,000 questions, but let me just come at it this way. So again, I referenced before the journey that I and colleagues have been on recently, the National Academy Report on Incarceration, and we ended up in the penultimate chapter of that book with the help of people who study legal theory and philosophy and the like, talking about normative principles as ways to think about criminal sanction in a normative context. So it's not simply a question of effectiveness, meaning behavioral change. That's that sort of can get us, can take us too far. We can do lots of things that are quite draconian in hopes of behavioral change. In fact, we've done those. So what I was struck by, Cecilia, is that in your, not highlighted, but embedded in your presentation, you used the following words: dignity, autonomy, legitimacy, justice. I would add one that you interestingly, unless I missed it, didn't use, which is accountability. So my question may be a version of Kevin's, which is, what are the constraints that are normative? on this extension of state power over the lives of individuals that therefore don't lend themselves to cost-benefit analysis, such that you would say at some point the state should be, by either legislative action or administrative rule, when it supervises people who are free in the community, should be so constrained from exercising that supervision, because the countervailing values of human dignity, you sort of touched it, human dignity, autonomy, what should we just not allow ourselves to do? That's different from saying, asking what is the affirmative case that you, I think, are moving towards, which is to say, can probation actually advance these ways of being, relating to each other, advance human dignity and autonomy, and can the rule of law through probation reimagine, enhance the legitimacy of this apparatus we call the justice system, rather than to either diminish it or be neutral. And related to that, to me, always is the question of the originating event, usually between two people, adjudicated in a court that we've set up because we think that's the way to do things, with lawyers on both sides and judges and people in black robes who then say, you are convicted of a crime, and then we send you off into this administrative netherworld called supervision. And what gets lost is the triggering event, the conflict, the harm caused by one person to another, and the sense of individual responsibility of the person we're now trying to, and I'll put this in quotes, fix, where the separation between that event and what the state then does to that person, to me, is antithetical to the notion of justice. So there's a victim who's been harmed. You mentioned fines, not restitution. I don't like restitution particularly. I don't think it does a lot. But there's something that happened between two people that we tear apart that conflict through adjudication and now through supervision. And even if we were to promote the values of autonomy and dignity and the other good things I talked about, and accountability for me is not just you have to show up every once in a while to a probation office. It actually is a deeper moral accountability for the harm that you caused. So is that part of your vision of a reimagined supervision system, parole or probation, but mostly probation, that would say, well, actually what really needs to happen next is some personal coming to terms with what brought you, Mr. Defendant, Ms. Defendant, here in the first place?
Yeah. I'm so glad you asked those questions. They're actually all ones I've been thinking about a lot the last 2 years, but
Are they
especially.
in the rest of the paper that I didn't read?
No, they're in the new paper that I'm writing right now.
Okay.
And the ones I haven't done yet. So one of the things that after I wrote this paper and as I was writing this paper, I thought about how much I do respect probation and think it has a place. I watch officers engage in the most incredibly intense ways with people in moments of vulnerability and helping them through healthcare crises and counseling them on relationships, right? Doing good work and meeting them as people in ways that did affirm normative values like dignity. But I also kept thinking in the back of my mind, yeah, but she's got a stick in her back pocket she's not using, right? And is it the role of the state to do these things when they can be abused? I think of Alice Goffman's book. And the idea that knowing about people's lives, right? Good probation officers know about your mom and your girlfriend, and they ask you about how your kids are doing, and they care. But knowing about your mom and your girlfriend in Alice's work also means I can go break down your mom's door when you go missing, right? That's the abuse of state power. And I'm still working out, I think, where the line is between the state's benign use of its resources and all of the ways that we historically have abused our best efforts. I'm working on a piece now talking about this in the context of evidence-based practice, which a lot of people in the field are really hoping is going to bring about positive change, but which in many ways look like a lot of the tools we've used in the past to oppress people, right? The collapse of the rehabilitative ideal was brought about by a lot of concerns about government overreaching that I don't think we've adequately addressed. So when you talk about what are the limits of state power, I think, we could maybe carve out some categories for greater concern. And I think, for example, I worry about some of the rules that limit who you can associate with. Because so often we say, oh, no other felons, unless your agent says fine. Right? But as most of us know, a lot of people's relatives are convicted felons. And I don't know how much I like the state saying that you can't go to grandma's birthday party because your brother is going to be there. Okay? Or telling you that you can't live with the person that you love and the mother of your children because she has a record. I think that the best we can do right now is to be conscious of the potentials for abuse inherent in our power and to be alert to them and create spaces where we can have conversations about the ways in which our behaviors as agencies may be creating ethical dilemmas in the field. Because right now I don't think we create spaces to talk about the bad ways we might be wielding the power we've been given. We only talk about the good things we can do with it. And so I think you're right that normative values have to animate this conversation, because while we may be seeing some move in mass incarceration, it's politically exciting for legislators to think about how to save money and spend less on prisons. But money doesn't bring about sustained change. The only thing that will is changes in our values.
So this is the point we'd like to invite everyone into the conversation for the balance of our time, and I invite you to respond either to the dialogue thus far or elements of Cecilia's presentation or something else in this general topic that interests you. So the floor is yours. Who would like to start us off?
You're looking at me.
I'm looking at Rocco.
All right, just get the ball rolling. Rocco Posey from Westchester. One of the things that strikes me is what role does probation play in determining who gets probation, what the conditions are, and how long they should be on probation. Most of the time, these decisions are made as part of the plea bargain. And there really isn't a whole lot of information that may be available to the court or to the district attorney or even to the defense attorney that would be extremely important in crafting the conditions and the length of time that a person should be on probation. We do pre-sentence investigations, which are just that. They're after the determination of the plea, and we provide information, but the deal has already been struck, quite frankly. And for us to get things put in as part of that sentence sometimes happens, but most of the times they're going to go along with the plea that's been negotiated, the conditions that may have been negotiated, and then probation is going to be handed the case with a person who perhaps we would have recommended maybe get a fine, or maybe they should be doing time in a local lockup or maybe in a state correctional facility. But there has to be a mechanism to allow for information to be available as part of the pre-plea, not pre-sentence, pre-plea investigations. And I think that would be extremely helpful in maybe limiting the exposure that we are now having in those three areas that you identified in the paper.
I just want really quick, just because I have a mic in front of me, but I also want to point out that it is no longer the Cecilia Quindle Show. And we hope that from now on, everyone will engage in a robust conversation in which I'm going to try to be really, really quiet and take lots of notes. But something you said sparked an answer I omitted to Jeremy's question, which is what about the role of restorative justice? And my response was going to be that while restorative justice is a critically overlooked and incredibly important separate consideration that we should have as a society, I'm not sure criminal justice does it super well. Whether it should exist in another space is a good question. But my concern about the criminal justice system mandating restorative justice is the plea problem, that we don't actually know what happened lots of times in the fights between individual people. And because we're working with such imperfect information and the crime of conviction so often poorly reflects the underlying facts of what actually occurred in the case, I think it becomes very difficult for us to say, hey, we know what happened, let's work on restoring the harm, because we're not even sure what the harm was or the dynamics around it a lot of time. Okay, now I'm getting.
So let me follow up on some of that, because restorative justice is one thing that we're looking into, but not in its traditional way, but its application. Restorative practices to case conferencing, that's our preferred way of doing quote unquote graduated sanctions, because it allows for the values that were raised before of dignity, self-efficacy, accountability, etc. So I think part of what we need to do is also figure out like what's the point of probation. I disagree with you that probation is not an alternative to incarceration, and that it cannot be, and you're not saying it cannot be, I understand that. So that it should be, and it can be, an intervention, an intervention about behavior change that is tailored around what happened in the criminal history, and because we do forget sometimes in probation, I believe, sort of the factors that led to the crime in a way, because we're so eager sometimes to, person comes in and we're just trying to figure out what services they need, right? And that there isn't the accountability piece of as to helping the person work through what happened here and what the pattern of behavior, if there's been a pattern of behavior or crime, you know, how it's led up to where they are in life. And for that you have to have a fundamental belief in people's ability to change. And for one, I want our probation department to have that fundamental belief. Now, some people are going to take longer, and some people are going to take shorter. And the people that take longer, then you have to figure out how much public safety issues you're going to tolerate, you can tolerate, because those are the harder cases, obviously. The people who, in the process of changing, have still too much, you know, misconduct, if you will, you know, in their life. And so I think so that's the ultimate goal, really. And I think it's doable, and I think we can have the best practices, motivational interviewing, stages of change, you know, restorative practices embedded in what we do to really, you know, treat people as human beings and a one size fits one, you know, kind of approach.
So, you know, I made a lot of notes, and I remember a conversation with Marty when I first joined the Division of Parole over there, and he said once to me, Raul, what if we just throw the whole system out completely and just give somebody a ticket to go get services? Remember that, Marty?
Yeah.
You heard that before, right?
Yeah.
And get services.
One persona non grata.
Yeah, I know. And that stuck in my mind for a very long time. Of course, some of you know, some of you don't know that I started out my law enforcement career as a police officer, and I was quickly shot by somebody under your supervision, somebody in supervision, and spent a year recuperating from that. So I want to put it in context, because I truly believe that in the entire system, we overuse everything there is in criminal justice system. Significantly overuse it. And there's a lot of reasons for that. And there's no use repeating it over and over again. You know, I mean, all we have to do is look at the pages in the newspaper about criminal justice for revenue sources, and it doesn't tell you much more than that. Employment opportunities through the criminal justice system, how many people are employed in the criminal justice system. I once spoke at a group of African-American young men, and I said, if you really want to hurt the white guy to stop committing crime, you're going to put a lot of people, white people, out of work. And, you know, they stood there and looked at me, but, you know, if you just imagine if all the people of color, men and of color, just didn't commit any crime, they'll probably figure out a way to arrest you somehow, but most likely you would do a significant damage to the criminal justice system as far as the infrastructure. So to me, less is so much better. I would prefer, instead of a probation sentence in most cases, either the person get a short jail term, a week, 10 days, and it's done. You know, you get a parking ticket for parking illegally. You get your parking ticket, you go and you pay it, and you go about your business. And if you park again in the same place, you get another parking ticket, you pay it, you go about your business. After a while, you say, you know, it's affecting my paycheck, I'm not gonna park there anymore, or you can tell you're paying. It's cheaper. In New York City, UPS is cheaper to park, double park every single day than it is to find a parking spot, so they make part of their business. The reality is that we overuse the entire system significantly. We heard about individual responsibility, absolutely. If somebody commits an act, there should be absolutely individual responsibility. That's why they pay the ticket. So if an individual commits a crime and he can't pay a fine, and he has to do it short term, so be it. Just a short term, he goes about his business, and he can do that over and over again. When I happen to have been an unlucky person to be convinced by a friend to stay with the local Judicial Police Commission, I would see thousands and thousands of cases of repeated offenses of individuals doing these short terms, completely waste of time. They were the same people over and over again. Those sentences could have been a week instead of 8 months, easily, and save a ton of money. If you want to punish somebody, you don't want to use jail term, how about some community act, some community supervision where if you want to supervise them to clean up the snow around the curbs of New York City for a week, even if you have to freeze your toes in the process. You're actually doing community work, and you're actually paying for your act, and none of that will do, which is the most damaging part, among other things that I think does, and it does it to everybody that it affects, obviously affects us, people of color more, which is the old proverbial number. The one that I hate the most, the one that was left in Germany to the Jewish people, and now it's left to the Latino and Black people throughout the United States. That number will destroy you. I can tell you personally that at 15 I was arrested for stealing copper, right? I happened to be 15 years and about 300 days. I was a few days short of being 16. So I was arrested, taken down to the police station, taken to the local lockup. My father went and picked me up. I was sent to family court, and the judge proceeded to give me a tongue lashing about, you know, stealing copper, and my father stood there, cried in an open courtroom, which was the most painful thing of the whole process, and then he put me on probation. And I served the probation, you know, with my probation officer being my father, and when I was done, I was left with no criminal record. That means that I would not be here today if I would have been 8 days older, because I would have gotten a felony criminal record, most likely, and I would have never been able to do the now numerous jobs that I've had in the criminal justice system. So the reality, the most damaging part of the whole process would have been the thing that I didn't get, which is the criminal record. If you want to do anything about this system to save young people of color, or anybody who is young and stupid and misguided and not properly parented, is don't give them a record. If you can do that, if you can stop that, that will be more to change the system than anything else you could ever do. That's what the answer is. Thank you.
Judge Alvarado, and then Judge Martinez. I know, but he was asking.
Did I have my hand?
Oh, you did?
Because you know me, you know I have something to say all the time.
I know he's coming.
I appreciate the dialogue that's taking place, and I particularly enjoyed reading the article. What amazed me about the article was that it did nothing to address the misperception in the United States that incarceration is the only solution, and perhaps that accounts for the numbers that we're seeing, especially compared to Europe. I've had the occasion to go to Europe several times with the State Department, and they're amazed when they say, oh, what do you mean your conviction lasts forever? So that's an interesting thing that we don't address here. But perhaps the most telling point is that we need to do something to educate the public, and the newspapers are part of the public, because the expectation is that once someone comes before me as a judge, I'll be able to solve all the ills of society. So if I give somebody an unconditional discharge, I'm a liberal judge who just gave a slap on the wrist. It's amazing how serious graffiti is until it's your son who's arrested for graffiti. And all of a sudden, that has to be prosecuted with a liberal mind to make sure the person doesn't get a conviction. But if it's somebody else's son, particularly Black and Latino, incarceration is the answer. I have to give a shout out to probation, New York City probation, Bronx probation, because I work with them. And I don't see a lot of technical violations before me that aren't preceded by a real effort to get somebody to comply. And the efforts being made by probation now to be involved in people's lives and to do positive things to assist them in staying out of my courtroom again are absolutely commendable. So that needs to be recognized. I'm positive that the representatives from all the probation departments are doing that because there is just not enough space in the jails.
Yeah. I think the voice that we've not heard so far is the frontline workers, the probation officers, even the parole agents. My work in California and in jurisdictions around here like New York City can attest that when the pendulum swings completely the other way from zero tolerance to hands off, let's not revoke, as you're seeing in California now, and also due to the policies in other jurisdictions, even with an agency I've been working with in the Midwest, then the probation officers, and I'll also, when I work with parole officers as well, they get very upset because they truly believe it's perceptional, but there may be some truth to it, that coercion therapy is an integral part of supervision. That if you don't have that stick to get people into treatment, then many of their client population talk and pass it on to other people that, you know, your chances of getting sanctioned are really remote. So you don't really have to comply with a lot of the conditions of your probation.
Zero tolerance for the behavior, but not zero tolerance for the person, right? And so you have to have those two things. And I think that when you can work with the frontline staff, which you know, we're working on and have made a lot of progress, I think, is to see themselves as an and type of approach, not an either or. You're not like law enforcement or social worker. You're an and. You need to both aspects of it. And if you have both aspects of it, you can reduce a little bit the real concern of abuse of power, obviously, of that state becoming just too much, right? Or to have imposed conditions that really end up piling up and piling on and piling on. I've seen my fair share of those. So, you know, the violation, the finding of a violation because of lack of work, but then all the appointments are during, you know, with probation are during the day when you're supposed to be out there looking for a job. We don't see that anymore that much. And so I think that we're trying to use filings of violations when we really mean it. I actually would argue that the revocation rate should be high if you're filing the violations that matter, which are what you were saying before of, you know, whether technical or not, that are really about public safety. It's really a public safety lens. So if you use a public safety lens to file a violation, then you want a revocation. You know, there are times though that, you know, I've had these conversations with judges where the judges sometimes do want a violation that's technical to seek for a judicial sort of reprimand type thing, or Raul call it tongue lashing, you know, might, you know, do a little kickstart on someone to use it as a tool, also almost as a case management tool. That's a little trickier, obviously, because it depends on the judge, and you don't want to expose somebody to being incarcerated unnecessarily. So I find that the violation of probation practice is a little bit of an art form, rather than something that can follow a script, you know, in a way.
Judge Bermudez? No? Okay. Patrice?
Building on what Anna said, I was struck by that and was going to mention some of what you said. The approach that we always have to take, and I've been doing this for a really long time, longer than I ever like to admit in public, because it really makes me sound older than I even am. But let me say,
you can't be older than you haven't been doing it longer than Rocco.
About the same amount of time I think. It's probably, I think it's been my only adult job, and I often feel that I grew up in probation because I was that young when I started. I was like right out of college. I have seen this at every level, and I've seen shifts over the years. I've seen shifts in the approach of the frontline workers. I've seen it I guess, coming out of college, following the 60s, not long following the 60s, there was a more liberal bent. However, I came into a department where I saw people who had been around for a lot of years, and some of them were much more law enforcement oriented. And then I've seen it shift in the other direction. And recently, I've seen with some of our younger probation officers a shift back. A shift to almost trying to emulate a police approach. And what I find, you talked about a disconnect with frontline staff. Yes, I think that some of our frontline probation officers would consider me bleeding heart liberal, quite frankly. But that's the point. There is moderation, and that's what there needs to be. And there always needs to be that approach. And we talked about the frontline staff, but one thing that we have worked on, a considerable amount that I've been working on in the last several years, is that, I come from a department where there are 10,000 people in Suffolk County on probation. That's a lot of people, right? We have a fair number of probation officers. I cannot know what's going on with all of those. My frontline staff do. But one of the areas, it may not be that easy for me to reach every person working in the probation department, but you need to work with your supervisory staff, the people in between, the people who take your policy and translate it and bring it out to the people on the front lines. And we are never doing our job if, when someone is not complying with their conditions of probation, we're not doing our job if we're not examining each of those cases to say, well, what should we be doing? I know that there are probation officers who have non-compliance and who simply would write out a violation of probation. I also expect that I have supervisory staff who are going to look at that and say, I don't think so. What have you done to address this? And I think that we have to remember, and it is a very difficult line to walk, but the correct line is usually somewhere down the middle. It's not on either end. You're neither these are the rules, these are the laws, this is what we're going to do, and it's not, well, we have to understand that, there are going to be all of these problems. Somewhere through the middle is where we have to walk. And it's a difficult path to do that, and it's hard to know which side to come down on all the time. And that is not, it is an art. You mentioned it's an art, and it is an art. And it's an art that we should be trying to develop in our probation practitioners. And it is not easy. And we all come to the job with certain perceptions. Some of them change over the course of time. Some people don't change. But you have to work on it continuously, and that's the job of all of us, and all of us who are sitting here work on that on a daily basis. And if you're doing your job right, you probably, in your department, have some people who think you're too liberal and some people who think that you're too hard, because that's where the line is. And I will not continue on that topic, but I do want to mention that I think it's important to bring up here in terms of that fewer people should perhaps get a probation sentence. And that, is undoubtedly true. We've all been around long enough to see people who were sentenced to probation who, they should have gotten a jail sentence. There's no two ways about it, whether the evidence wasn't that good and that's a plea was made, whatever it may be. And there are other people who come to us where it's like, wow, these people, they made a stupid mistake, but they probably really don't need to be on probation. But we're going to get those cases. We have to figure out how to deal with them. But one of the biggest issues, and we'd be remiss if we didn't mention that today, and I want to mention it because it wasn't mentioned in the paper, is that we get truly troubled people on probation. The mentally ill are increasingly being a large percentage of our probation population. Some of them very seriously mentally ill, some somewhat less seriously, but enough that it is really having an effect on the way they deal with society and on the way they conduct their lives. And that is an area that is something that all of us have had to deal with. And those people, in some cases, the probation officer, and I see this all the time, are the ones who are trying to keep them simply going. And I don't mean out of trouble. I mean out, having a place to live, food on the table, and just putting one foot in front of the other. And it's a difficult role to play at the same time that you are in charge of enforcing the laws. Some of these people commit crimes because, you know, their mind is not working well enough to keep them from committing crimes. And this is a real area that we have to think about, and it's something that I think everybody in this room has concerns about. Thank you.
If I may, exercise the prerogative to follow up on that issue, is it your perception of that of your colleagues, yours, Anna, that your probation officers have the tools and the skills and the resources at their disposal to do the tasks that you've outlined, that sound like very noble tasks?
Well,
how do you find housing? How do you find
right.
employment? How do you find treatment for the mentally ill? Do you have the tools, the resources, the time, the capacity?
No. I mean, that's the simple answer, no. I think we try, but I think that is great difficulty. Housing is extremely difficult. I mean, people wind up in jail because they'd be on the street otherwise. They have no place to live. They're mentally ill. They commit a crime, and I think sometimes, I mean, we would find other places for them to be. We'd find other sentences. The court might do something else. They put them in jail because at least they know they're not sleeping on a street corner. It's very, very difficult. And no, I don't think they have the tools. I think we work on it, and that obviously is something that goes beyond just what probation can do. But you know, we all live in part of a larger society, and we try.
Just a comment, an additional comment on that. You know, one of the things that we always, I ran the probation program, proud to run it for a few years, and also the parole division for the state of New York. And we always, you know, had the concerns about the work and what was expected of the probation and parole officer, the role, the constant pressure of these two roles, that of the so-called law enforcement role and the social work role, kind of always pushing against each other, was a real pressure on the officers. And you know, sometimes it was just easier to go to the law enforcement. That's the easier one of the two. I mean, it's most dangerous, but it is the easiest because it's very defined. You know, it's exactly what you have to do. The social work is undoable, and with the type of individuals that you have assigned to you or to a caseload and the size of the caseload. So the one is easier, and once you buy into that, you really do then become, you start going into it all the way. Marty and I remember a particular incident where we were doing relapse prevention training for the officers for the first time, for the parole officers. And we sent the training crew out to Long Island, I believe it was, to do a training. And the entire parole class turned their back on the trainers. They just refused to participate in the training. It was almost against everything they believed in or what a parole officer should be. And we had to send the director from New York City out to Long Island to order the parole officer to turn around and listen, which was simple relapse prevention training. So once you flip to that end, and we really believe that the only job you can do as an officer is to be a guard, a watcher, and get in there quickly before the individual commits a crime, so that you don't read about yourself in the papers that you failed to supervise and therefore you got a crime, and you buy into that, you're gone. And it's a very difficult job. I find the job almost undoable.
Right.
I've heard it described as going to the dark side.
Just a couple observations, if I can. I think as probation has become the sentence of choice in America, it has not been the funding choice in America either. If you look at the Pew study, and if you look at a couple other studies that have been published, as you see the rise in probation populations and the decrease in the incarceration rates, there hasn't been a commitment on part of the funding streams to increase the number of officers that are needed, programs that are required in order for us to deal with whether it's the people who have mental illnesses, sex offenders, or wherever, whatever problems that they have. So you've seen almost like a flatlining of the funding streams to probation as you see the spike in the number of cases coming to probation. So I think that has been that has been a major problem. That there's been a lack of support, to allow. Like people ask me, does probation work? I said, well, if I ever get a chance to do real probation work, I'll answer your question. Which means my officers have caseloads that are workable. We have programs in our communities that are available. There aren't waiting lists to get people into these programs. So if those things can happen, I would think that you would probably see a much better result. Just another observation too. I think we're not completely helpless in probation either. I think we have become sophisticated enough now that even though we don't have any control over who may be coming to probation, through the use of risk instruments and needs instruments, we've been able to identify those who are low risk, low needs type of individuals, and as the research is telling us, that we really shouldn't be putting any eggs in that basket, that probably they will do a lot better off without us than with us. So the challenge is to find out in probation who really needs our services. And we need to carve out that population, and I think it's almost the extremes. The people who we know who are not going to make it, those that stand in court and say, in 24 hours you're probably going to be back in court again, and those on the front end that don't need our services at all, we really need to carve them out, and we need to focus in on the people who really can benefit by our services. And I think Anna has said a key word. Our challenge is to try and keep this all in balance. We talked about Jeremy, talked about accountability. Yeah, we have to hold people accountable. But why are we holding them accountable? Well, we're holding them accountable because we want them to do things to correct the issues that got them on probation to begin with. Is that not our goal? To try to deal with those issues? So sometimes we need to hold people accountable, and maybe have that sword of Damocles sometimes hanging over their heads, but in a positive way, to get them into the areas to start dealing with the issues that they have. And that's not for everybody. That's just the people who really require our services.
I think we're going to go to the judge next, but I want just one follow-up with Rocco, if I may. Rocco, you talked about the underinvestment in probation. My question is this: is, in your mind, that just a general reflection of underinvestment in the public sector, or is there something about probation's inability to attract sufficient funds? Is it probation specific? Do you feel it's a lack of appreciation for probation and the money it needs, or is it just a reflection of our times?
I think it's a lack of appreciation. I think it's a lack of understanding of what we do. I mean, most people have no idea the things that probation does in the criminal justice system, quite frankly. And I think if the general public knew, and I would think if our legislators knew a little bit more, and we tried to do education. I mean, Marty, Mike, all of us that have worked together for a number of years have attempted to do that in New York. And it's gotten us 10 cents on the dollar now, and that's how good of a job we've done. But there's a real lack of understanding.
Wait, that's not up from 0, that's down from 100.
Yeah, but it's just I think it's really a lack of understanding, an appreciation of what role we play and how important we are in the criminal justice system. Because I think if they were aware of that, I think the funding would follow.
So we'll manage the queue here, but the judge is next.
What does that mean, we manage the queue?
The line, just the line question.
All right. So some observation, and mine comes from 40 years. I don't mind saying that I've been doing this for 40 years. And it seems to me that, Commissioner Posey, you're right. People do not understand what the purpose of probation is. Even in reading your wonderful article, Professor, I was saying, well, is it affirmative, we're going to change people's lives, or is it punitive, we're going to put people in jail? And obviously, it's a little bit of both. One of my problems is in trying to answer your question, Professor Travis, how do we have a link between this act in time that created the criminality and the future consequences? It is, for me, when I look at the criminal justice system, I see the element of controlling a population seem to be a dominant issue. I think there are many people of color who will say that the system, and almost every one of its stages, is about controlling. So I get very upset when someone says, well, they have this misdemeanor conviction for marijuana, or we can get them services. So why is it if you come from the South Bronx, the Barrio, Bed-Stuy, in order to get services, you have to have a criminal conviction? But based on what I see on television and intervention, a lot of white folks are using a lot of drugs and they're all going to private programs. You know, I had in my work as a dean of the Judicial Institute, I get calls from judges all over the place, and I got a call from a judge from his place in New York State, which remained nameless, and an African-American judge, and she said to me, do only black kids commit crimes? And that's not a rhetorical question. Yeah? The black kids are not the only kids who commit crimes. So when you talk about something about the link between conduct and consequences, after reading the article, I may never, this may be good for you guys, I may never sentence anybody probation again. Because I think that collateral consequence, which I think is too harsh, is dramatic in the light. Look, the commissioner would never be a commissioner, but for the factor of his birthday. So I'm concerned when I look at probation about the time, because I ask the question, if in one moment in time a person committed a conduct, how long should the state control his or her life? Do we really need, if I'm a young person and I'm put on probation for stealing a very expensive car, let's say, do I really need the control of the state of New York for 5 years? Or, you know, I can get out of high school in less than 5 years. So what am I going to learn? What do you want me to think, to know, to do that's going to take me 5 years, where a year might be just as good? And so I am very concerned about how long do we keep people on the control of the state when we know that every day creates the possibility for a consequence that's negative. And it seems to me that is not well thought out, and that, my experience as a judge, I was always happy to let people in their probation early, but even those rules are arbitrary, that you have to be there for so long. Well, if I do a good job for 365 days and I'm 19 years old, I'm at John Jay College, I'm doing whatever I'm supposed to do, why do I need to go for some more days? It's just really about that issue of control. And when you look at the history of people of color in this country, you wonder sometimes if the overarching issue is to keep that body of people in control. And that may not be the goal. The goal may be more altruistic, but sometimes you feel that that law enforcement perspective that attends the criminal justice system overall may be a too dominant system and doesn't necessarily produce rehabilitation, which we used to think was the ultimate goal, a laudable goal. It doesn't necessarily produce reparation or reconciliation, but it does create, increasingly, no matter how well people do their job, this continuing under this class of people who are always in a role of control. But your report was excellent, and I think that focus that we should not let the criminalization of certain conduct in the lives of certain people continue to persist in our community. And I'm not sure I like the word accountability. It means too many things to many people. Sometimes it feels like it's more negative than positive in terms of the sense of improving a lot of everyone. But like I said, I think that also one last thing. We know it's there. It is ever present. But the policy of plea bargaining, which controls almost everything we do, has a negative consequence on this as well. And so sometimes before there was reform in the drug law reform, you would have someone in your courtroom today, he or she would plead guilty to lesser B felony, get probation, and you knew that that was with two purposes. He or she would be back before you, probably before the year was over. She would be a felon back in his felony offender, would go to state prison, would not have the probation, but it was almost like an unfair dangling of a jewel to this probation that we all knew nobody was going to complete.
I actually want to sort of add to that. Thanks, Judge.
Excuse me, just if I may. We promised Bill Leahy and Michael, and then yourself.
Oh, Bill goes first. That's
Bill?
Bill goes. Go
Okay, well, I was going to make one point in response to Cecilia's statement and one question that I'd like to put to the probation professionals who are here. But I think in light of Judge Richardson's comment, I want to share an anecdote. I've said it many times in Massachusetts, but I haven't said it during my 4 years in New York, that relates to this disparate treatment. And it was my day and night jobs in Boston. I worked in downtown Boston in the daytime as chief counsel of the statewide public defender agency, who represented many clients of color, many clients who served long mandatory prison terms for drug offenses. And at night I'd go out to my bedroom community 10 miles away. And one Friday night I got a call from very good friends, one of whose sons was a very good friend of my son. And it was, he's been arrested, here's the name of the police officer, could you please call him up? And so I found out that night about the way the criminal justice system really operates. And because I went in and talked to the sergeant and good family, and a case that really involved selling drugs, not just within 1,000 feet of a school, but in the school parking lot, as school was letting out, turned into what we would call here an adjournment and contemplation of dismissal, without even a formal arraignment. And that young man, just this week, I learned, is now entering graduate school with no record. And it has to do, obviously, not only with race, but it has to do with the opportunities and the divisions in our society. So I just wanted to make that point because it underlines what you've said, Judge Richardson. My point about the article is, I love the very last line, Cecilia. You say that we have too many rules placed on too many people for far too long. It just kind of encapsulated the whole point. And of course, it's really inarguable, all three of those points. My caution, I guess, is in, and not to the author, but really for all of us who try to move the system in this direction of allowing the probation officers to do real probation with people who need it and can benefit from their services. And I think Raul said less. Absolutely. The problem is the gap between well-intentioned proposals and what the political system does to them on the way. And I was thinking of that as I was reading the portion about the short incarceration terms. When I was reading it, I thought, I know somebody said 7 or 10 days. I was thinking 3 days in my own head as I was reading the proposal. I'm thinking, yeah, this does have promise. It's logically correct. You don't put those jewels out there to the person. It's unrealistic, and they're going to do a lot more time. And yet, I went a page later, Cecilia, and I saw that the typical short term in actual operation in the states where it does operate seems to be more like 90 days. So 30 times more than what I had in Bill Leahy's head. And so that's just a cautionary tale for all of us reformers as we wend our way through trying to change things. My question for the probation officers here, and this is just an incredible, unexpected opportunity for me. I didn't know you were all going to be here. I run this little office, 10 employees up in Albany, State Office of Indigent Legal Services, where we do grants to public defenders all around the state, including in the city. And one of the big promising developments in the public defender world these days is, you can call it client-centered representation, you can call it holistic representation. Suffolk County now has got a team of social workers in their public defender office, bilingual social workers even, I understand. And this is great. We're funding that in part. And so public defenders are kind of awakening to the need to do more for their clients than just kind of get the plea deal that throws them into probation. But I don't think, and here's where I'm going to throw the ball back to Tina, and maybe she can help me out here as we go along in this discussion if we do. We don't know beans, really, about your work. I mean, I've known some great individual probation officers, and we've had wonderful conversations, but I can't say I know your work. But my question is, what from your point of view could and should public defenders be doing that they're not doing now not to make your jobs easier, but to benefit their clients more than they're doing today.
So hold that thought, and we'll come back to it. Put you on the hook for that. Michael?
Well, just a couple of things. Actually, one, Jeremiah and I talked about this for a minute. Just one organizational point is that at some point it'll probably make sense for sort of Ron and Kevin to check in with Bruce Western, because there is this executive session at Harvard on community corrections that I'm a part of. We're into our, it's one of those traditional sort of 3-year looks at an issue, in this case community corrections. We're sort of halfway through. Vinny Chiraldi, Bruce Weston and I doing a paper on shrinking probation. Anyhow, I mean, there's just a lot of overlap there, so it just makes sense, I think, to check in. I guess just a couple of sort of real politique issues that are not particularly substantive. I try not to dirty my hands with any actual substance. So, I mean, I think as you said, Bill, I mean, the fact that there are too many people on probation for too long is sort of an unarguable proposition. Same as there's too many people in prison for too long. There are too many conditions, too many people go back. It's all true, but just focusing for a minute on the sort of what is to be done piece of that. Rocco's right. I mean, probation has always had trouble attracting resources, and the fact is it's never going to attract resources. There's no scenario where probation is getting a big infusion of resources. Not going to happen. Never going to happen. Only Bar Broderick. Only Bar Broderick has unlimited resources, right? I mean, that's just going to be the state of play for a while, and that's, there's a tremendous amount of knowledge and expertise in probation. A lot of those folks are here, but the sort of discourse around how you do that, how do you get people off of probation, how do you limit people onto probation, how do you keep them from going back to prison, that has to be way outside. That discussion and eventual action lays outside probation. I love, who has less juice in criminal justice than probation? No, maybe public defenders. I mean, it can't, probation has a lot of things, but power is not one of them. And for that same reason, they can't attract resources. It's just a structural position that they're in. And so when you think about how you're going to get to a point where less people come on probation, you keep people from going back. You're into the world of having to fashion a sort of legislative, political, and fiscal strategy, right? That includes probation, right? Probation is a necessary but not remotely sufficient part of that eventual solution. And so it's just so not you necessarily, but the royal you, right? People, experts, academics, policy folks, people who think about this, have to start thinking pretty specifically whether it takes the form of, California's realignment, which in essence, I mean, it's probably the largest piece of criminal justice reform, good or bad, that's been done in a century. It sort of had nothing to do with criminal justice, but just a fast reaction to a lawsuit. But whatever the political and fiscal strategies that make the most sense are, whether it's Washington State's kind of legislation that keeps people from coming back, whether it's redefining probation terms, this is a in the muck sort of state by state strategy sort of thing, and the discussion rapidly has to get. This is a discussion that you obviously need to have to sort of get the substance behind that, but in the end, this has to be done by people who, in essence, probably couldn't care less about the substance of this, right? So you have to start thinking about fashioning arguments that are, you know, part substance, certainly have to do with values, probably have something to do with money and some other political strategies to get from here to there. Because I think what you're advocating for, and I thought it was a wonderfully and well done piece, but to get from the here to there piece, that takes a different level of strategy and thinking.
Justine.
So in reading this article and sort of thinking about what the role of the public defender or any criminal defense lawyer, frankly, and sort of the calculus that we advise our clients on, and then listening to some of the comments. So Professor, when you said that one of the ways in which what population should be involved in probation, you said, you know, people who are willing to benefit. Or when I hear probation saying, you know, we often wonder sometimes, why did this person even choose this? They were going to fail. There's a conversation that needs to happen about why people make that decision, and if it's in fact a real decision. Because what we need to talk about is bail. Because for the public defender, for the client, for the people we represent, there are often times we would like to say to our client, well, we should sort of, let's get to the suppression here. Let's see what happens. But bail is set. And if probation is dangled in open court in front of a client as a deal because bail has been set, I'm telling you, a client is going to go home. So what you all then deal with are people who sort of felt like that was their only option. And they're not ready to actually be willing to benefit for the services that you all try to provide. But that was their choice. That was the only choice. And so it would be really interesting to sort of have a conversation about how bail drives most of the statistics across in your article, Professor, because it is sort of the only choice. People have sometimes to go home, particularly the populations we serve here in New York, and we service up to about 220,000 people in the criminal justice system. I firmly believe in the less, particularly we see in New York City. You know, our probation for the state could be on a misdemeanor, could be 3 years, could be less, but you know, yes, you wince, right? So think about that, and let's now think about the population that is actually getting arrested on misdemeanors and driven to the system on misdemeanors. They are poor, younger, Latino and African American, mostly male, but certainly also females. And so, with a 3-year probation on the table, they may go for that. So then the question is, really, is that where it is? So now to talk about your point, Bill, which is, you know, what do public defenders know about what really probation does? I will say we are very lucky, and it's not because she's just sitting right here to my left. We are lucky, actually, to have a probation department that is ready, willing, and able to have conversations with the defenders in New York City about our clients and what we think, what we hear, and what our social workers know, and really looking at things like limiting how long the person should be on probation, and then maybe sort of talking to the judges and sort of having a training that, you know, judges actually could, under the present law, give less than 3 and less than 5, and maybe that would be the way to get less. And so it's a start of a conversation, but I think we fool ourselves if we are just going to sort of talk about probation and, in fact, even community supervision, if we want to do that, without having a real discussion about bail. Because clients will plea, and they will plea in arraignments, and they will plea as soon as possible to go home, even when they are not ready to sort of accept services. So, you know, that's where I think the conversation should go from here.
Sean?
Yeah, I have a number of points as I listen to this that hopefully will be useful. First of all, as a social scientist, I have to sort of point out in the report some language things I think are important to sort of note. In particular, with respect to things about that we actually know, and this idea that we know that someone's going to come back. There's a huge history of risk prediction, and we know we can do better than guessing about who's coming back. But the idea that we actually can predict with certainty who's coming back and who isn't is wrong. It's not true. And it's one of the sort of the facts of this is that what you're really trying to predict is who's not going to recidivate, who's going to stop. And predicting sort of levels of offending is one thing. Predicting who's going to stop is really hard. And what we do know is that even the highest risk people, there's a subset of folks that are going to stop. And so I think we're really careful here with language that says we all know, because I don't think we do all know. And if there is, there was a large discussion about selective incapacitation about 25 years ago that was placed on its head in part because we don't all know. And maybe we do a better job of predicting the low-risk people, and that's some of the premises of R&R, that sort of has set aside. But I think we have to be somewhat cautious about what we know vis-a-vis prediction. And I think that's important caution. There's also, I think that the underlying premise of this exercise, in terms of we should be looking at probation and revocation because it's the reason for mass incarceration, is in some sense flawed. And it might lead us to problematic conclusions. Because one of the underlying things that I think people keep missing, and it got brought up here a little bit, was that at the same time we had a fourfold increase in the prison population, we had a fourfold increase in the jail population, and a fourfold increase in the probation population, and a fourfold increase in lots of other populations. And when it's starting to come down in places like New York, guess what? When the prison population comes down, so does the probation population. These proportions are almost identical. What's the biggest difference in the fact, and what's facing us now is that we've got a lot more people being convicted than we used to. And it's and in other words, the probability of being convicted given arrest is much higher than it used to be. And so confronting this problem, too much, if we focus first on incarceration, and now that we've sort of got attention on incarceration, we're going to focus on probation, and eventually we're going to focus on the fact that too many people get fines. I think we're missing the problem is that there's just a lot more people being convicted, probably because of plea bargaining or other changes in structure, but ultimately we don't understand the process that's generating the people that are getting sanctions in the first place. And if ultimately the issue is we want fewer people to receive these sanctions, then talking about any given sanction is misplaced. We need to be talking about the process that's generating the sanctions, because it's a fact, we're convicting a lot more people than we used to. And it's not fundamentally that we now send a lot more people to prison than we used to relative to probation. That's just not true. So the other thing I wanted to talk about in this context is, and especially because Kevin's sitting right here, the thing that it's already been mentioned a couple times, but what's the purpose of sentencing? And if it's punishment, that's one thing. If it's something else, whether deterrence, selective incapacitation, or something else, rehabilitation, then I think we get into problems if we don't specify what that is exactly. And particularly when it comes to probation, if I go to prison because of retribution, but then I go to probation and all of a sudden it's all about rehabilitation, we're sending lots of mixed messages. And I think that's fundamentally part of the problem. If the reason why you get probation is because it's less severe than prison, but then all of a sudden we're going to focus on rehabilitation when you get there, which is what the R&R model really has been, right? R&R has hit the probation folks the most, right? That all of a sudden we're going to start assigning risk. But if you talk to people about using R&R to assign people to prison in the first place, there's lots of people that think that's wrong, right? Because the only reason why you should go to prison is for retribution purposes. So I think this conflict is somewhat problematic and leads to some real, I think, problems in even what the mission is, particularly if it's respect to punishment. And it leads to fundamental conflict in the outcomes. One thing that hasn't come up in the paper that also hasn't come up here is the issue of racial disparity, particularly when we're talking about, so in academics we often focus on the racial disparity in terms of prison sentences versus not prison sentences and prison sentences of the length. And one of the issues that we notice is there's usually racial disparity in terms of who goes to prison or not. And there's some issues there, and that some of that may be based on choices. And it gets back to the issue of punishment. African Americans are less likely to think of probation as a good thing to do or take the diversion programs, and they're more likely to choose a short jail stay versus a probation sentence because it's more intrusive, more whatever. So the idea that somehow prison is always worse than probation gets thrown on its head and might in fact explain some of the choices people are making, but it's important to consider these issues. And when you start talking about alternatives to probation, guess who gets those alternatives more often than others? I probably don't have to tell anybody, right? It's white people. And I think that is harder to study, but I have students that are studying that, and I think it's fairly real. And we have to be very concerned about introducing additional racial disparity into the discussion. Two other points. Churning. Not just people coming back and forth to jail, to probation, but also back and forth to jail. I have a study right now. One of the things we find is that there's a group of people that prior to going to prison for the first time churn through the jail system. Churn, and they're never supervised in the state of New York. Basically, they're getting short jail sentences, they're getting time served, they're hitting bail. What happens? They get bail, they take their 3-4 months as time served, and they come back, and they come back, and they come back. At some point, if there's, and what happens eventually is they get sent to prison. And so there is a role for supervision, particularly for those people, and treatment for those people that are having struggle staying out in the community. And that's where the focus could be in terms of, because obviously if you're serving short terms in jail, you're not getting treatment. And finally, I would like people's thoughts on Swift and Certain, Project Hope, however you want to call it. I mean, that is one of the going concerns or active discussions currently going on in this field with respect to alternatives to probation, rather than sending these people to set longer term probations that have terms that may or may not be invoked, sending them to very short-term punishments that are linked very closely to very certain sanctions if you're caught. I'm curious that a lot of people are excited about that as an alternative to the standard probation structure, and I'd be curious to hear people's thoughts as to whether that's feasible, what are some of the downsides to that, because it is, we're talking about sanctions, they're experimenting in Washington with sanctions that are not even a day in jail. We're talking about a night in jail. It seems to work as well as 3 days in jail. So I mean, it's a question of an alternative approach that I'd like to hear people's thoughts on.
Sean, can I do one follow-up question to something you mentioned early on? You talked about the increase in the number of people being convicted compared to a period in the past. Have you ever thought about why that's happening, what's going on there?
I mean, this is an ongoing debate, and Jeremy, Mike, Professor Travis / President Travis, whatever was the right term, I mean, about what is fundamentally leading to the increase in incarceration, and I'm of the belief that and there's a number of other people that think this as well, that it's due to increase in convictions. In terms of the causal structure for why there's more people convicted, I mean, it's a little tricky to do this, to prove this, but essentially, it's a combination of, I think the cause is the increased use of plea bargains. In 1975, 25% of all convictions were the result of trials. Now, in many places it's 3%, and it's 5% in some other places. But essentially, a lot more people get convicted by plea bargains than they used to. And the question is why. If you believe Kevin's theory of how people end up being convicted, the idea is if there's a sanction threat that's now more certain and more severe, you're more likely to take the plea. And the movement, the sentencing reform movement towards determinate sentencing, which not only increased the sentence that you were getting, but also increased the probability of the sanction in a way, led to, it's easier to coerce people into pleas. One of the things that it gets talked about a lot in New York that I think is interesting, the fact of the matter is Rockefeller drug laws did not lead to huge increases in the number of people serving, if you think about the A felony, long prison sentences. That's not what happened. There was actually studies, evaluations done at the time. The number of people that got A felonies actually kind of went down. What happened was, because you were sitting there with the stick of the Rockefeller drug laws, lots of people pled to lesser sentences. They either got probation or prison, shorter prison sentences that otherwise wouldn't have been convicted in the first place. And so it's not that they served lots of long prison terms. What happened was a lot more people just got pled guilty. It's a little, and I think federal sentencing could have played a role in this as well, because particularly in the drug area, in 1987, the federal sentencing guidelines got a lot harsher. And so now, if you talk to local prosecutors, they're not, no one's hiding the fact that they use it as the hammer. If you don't play ball with me in state court, I'm going to send you to the federals. And the federal system was much more draconian and much harsher, and therefore people were much more likely to induce pleas. But I mean, this is a hard thing to prove in terms of causal connections. But I don't think it's hard to prove that it's the primary reason why there's more people in prison is because there's more convictions. And there's more people on probation, and there's more people in jail.
If I may, sir, I'd like to get back. I'd like to try and get Sean an answer on this issue of swift and certain, the hope experiment. Is that something? I'm curious to know, Peggy or some of our other people, about whether that's doable in New York.
Well, I can't answer that, but I can certainly talk about the fact that it's spread like wildfire based on, in my opinion, and some of the research certainly that Vera's done, on an incorrect interpretation of the original model, which was of a single judge operating with his own probationers who he had been monitoring for a while very closely. These were not drug addicted, mentally ill people. These were the screw-ups. These are the people who screw up all the time. And so he put them in jail for short times, and because there was not treatment needed, this was just screw-ups. And part of it was, as we know from many of the best drug courts, most of it was based on his own relationship with these guys. He was a, you know, if you've ever seen him, right? He's a former Marine, Navy SEAL, something like that. He's about 5'5" and probably weighs 220 pounds of solid muscle. And so I think you know, a lot of it was relationship. But what we focused on was not his intense involvement with these people, his intense screening of these people, but rather we focused on swift and certain. And that's what was taken from the Hope Project and spread, rather than the many other, I mean, it's does the term fidelity.
Mm-hmm. Let me piggyback on that, because that's part of it. In a lot of the programs or initiatives that seem promising, I think we overlook the power of the transformative relationship between the people. I was just at a conference where it was hammered in again and again that for a traumatic brain, or a person with history of trauma to recover, it's really not the services that are offered, but the people either within those services or even with no services that matter the most to do the reattachment that needs to happen for that person to thrive, right? And so I'm totally with you on that. We tried in probation to do something like that. It didn't work, in part because we couldn't even identify the right people or what the model actually was going to be. I'm much more of a believer in having, and I'm a judge, I'm obsessed with the word accountability, actually. And I would love somebody to do some work on the word accountability and what it is, that it's not punishment. It is being answerable to someone, right? Again, the relational piece of it, and that's why to me restorative practices work so well, about your choices and what you've done and why you've done it, and how to sort of continue that reintegration into a harm that was done, right? And to be able to make it right. And so that to me should be at the core of any sanctioning, quote unquote, or consequence building, with people, because we also have to trust that people know themselves fairly well as to what works, what doesn't work. The hope type of ideal, I'm glad you mentioned the lack of treatment necessity, because it goes contrary to the research that goes into how people change and how they get over addiction, and so it just, again, depends on the purpose. So if it's just to, either punish or control or whatever, that's one thing. But if it's behavior change that you want, I just don't see how that goes with that project.
So now, because I'm up for reappointment at the end of the year.
That's a really close call, Marty.
Can
I jump in the queue? I'm sorry.
Yeah, no, you're next.
Oh, good. Oh, so this doesn't count for the reappointment? No. It's not a favor. So I'm not going to try to join in with Sean on this sort of question of how has the system changed, other than to point out the fact that the role of the prosecutor has changed enormously, and the additional power that we've given to sentence people to very very severe sentences and for a very long time, and in a generally more punitive environment where prosecutors run for office, has given prosecutors much more leverage than they had before. So just to state that. But as you may have gathered from my sort of earlier comments, I'm trying to look at today's conversation in the context of what's happened with the justice system writ large in our country over the last 50 years. So we have a lot of 50-year celebrations going on. John Jay is 50 years old this year. We have the 50th anniversary of the March across the Selma Bridge. If you didn't notice that this was equally important, that Sunday was also the 50th anniversary of our landing of the Marines in Vietnam. So lots of things happened 50 years ago. But one of the things that happened was the Presidential Commission on the Criminal Justice System. So a number of individuals, academics and law professors and others, set out to specify something called the system. Right? We now we've inherited this this image of the system, which is this assembly line version of justice that is, in my view, very destructive. It's destructive conceptually, because the way we think about what society's response is to the harm caused and, of course, the cause the harm. And we, a couple talks on this, you want to see my thoughts at length, but we've become very system-centric, and we live under what one speaks called the tyranny of the funnel. So this funnel that goes from this many crimes to this many reported to this many apprehended to this many prosecuted to this many convicted to this many actually going off to prison. That funnel is the tyranny, is our intellectual tyranny. We live under that tyranny of the funnel because that's the only way we think about things. What that means is that all of us in different ways look at our box within this larger table of organization and say, well, how can we do that box better? And Michael's not here, but to me, it would be interesting to sort of put a challenge to probation folks who are, in ways that Cecilia talked about, really good people doing hard work with in the field, great on relationship building, great on working with troubled individuals. In some ways doing the hardest work, I think, of all of the rest of us in the system. And no offense to judges and lawyers, but this is really hard work. But it would be interesting to give you the challenge of saying, how would you reimagine the justice system? I use that advisedly. Or the justice response to the harm created, right? Knowing what you know, having your professional toolkit, being able to relate to communities and individuals the way you do. So Michael's right that sort of continuing to plead for more money just to do what you're doing now somewhat differently, even very differently, unlikely to be successful. But imagine that you could sort of go back to first principles and be the agency in the community that says, we actually want to respond to that harm differently. And we have a toolkit to do it. So here's the exercise that some colleagues and I have been playing around with that would make that very real. So mass incarceration, a lot of money, a lot of people, a lot of deprivation of liberty, terrible, terrible thing. Can we move out of it? I'm actually very pessimistic. I don't think we can. But there's an exercise that puts probation into the middle of a different vision. And you would start by saying, in a community, here's how much the taxpayers in the state of New York pay to incarcerate the people from that community. This is the justice mapping work. You put that money at the center of a table, and you'd say to that community, not to us, but to that community, let's imagine that we cut that usage of that very expensive response to harm in half, and we went back to a 1985 level of incarceration, and we freed up X number of millions of dollars. Let's continue to play this game, and imagine that we took that money and actually invested it differently in responding to the harms caused by those individuals who are now in prison, and all those who never got caught, and all those victims who never reported their crimes. But we actually imagined a very different response to harm, the harms caused. How could you, dear community, do that better? Now, probation actually could be the leader, facilitator of that conversation in the way that none of the lawyers could. The prosecutor wouldn't know how to do that. Defense counsel wouldn't have. We're just trained differently. Right? Judges wouldn't know quite what to do with that. Probation can lead that conversation. Be right there. And then, as I say this with respect to all of my Brooklyn buddies, I live in Brooklyn, I say, then we imagine we're going to secede from the state. We're going to actually take all of our punishment power and say we'd rather reinvest those dollars very differently because we have a much better system in mind that is a closer approximation of justice for those victims, with you on that, Anna, for those individuals who are troubled, right, and don't get much from what we're doing now, and if we put into that something that's a less adversarial, less prosecutor-controlled system of finding the truth and doing something about it, then you could imagine actually doing something that would be very different and that would ramp down the incarceration jobs. So, if you live in Brooklyn, right?
Yeah.
Yeah, so you ready to secede with me?
I'll secede with you.
Okay,
I have a plan already.
You have a plan? Okay, let's do it.
Like, this relates to a story that we were interviewing at one point for our director of community communications, and in one of the interviews, the person we were interviewing said, "No, I do have to tell you that the name Department of Probation does nothing for you. What would you name it if you could? Rename it if you could?" So we were like, oh, joking, if we go over, you know. But the cabinet spent all weekend, this was on a Friday, texting back and forth. What about this? What about that? We settled on the Department of Community Justice, right? So if you name our department the Department of Community Justice, you're in the community at that point in time, right? Restorative justice can be one option. They can be, again, this conference that I went to was really great. They called these teams something I wouldn't call them. I would call them community justice teams, right? Made up of the principal in the school or the education person, a health person, a probation person, a sort of recreation, or leisure time activity person. And obviously the younger you get them, the better. You don't allow anybody to get on probation or anything like that until the age of 18, even then, right? So there's all sorts of things we can do if we even rename ourselves to be community justice focused rather than probation. That's one idea.
So it's a great idea. I don't mean to take anything away from the work of your team, but this is what Denny Maloney did in Oregon how many years ago, right?
There's no new idea in this business.
Exact same
okay,
process,
so,
and he charged each one of his employees $1 anytime he used the word probation. It went into a kitty, and then it sort of became there. But and then he went to all of the businesses this was in Oregon, in Bend, Oregon, and said to them, I have this number of people who are under my control, whatever that means. A lot of them able-bodied, ready to work. What do you want them to do? The first thing to do was build a shelter for domestic violence survivors. That was the priority in that. And then all of those probation officers, they weren't probation, all of those participants in the community justice program, when that shelter was built, lined up, and the TV cameras were rolling, and they passed the key, one to the other, gave it to the woman at the end, said, congratulations, you're now safe. Done. Right? So you just take everything and turn it on its head, and you say, we have value to add to the pursuit of justice.
And they went from there to building Habitat for Humanity houses, to building bus shelters, to...
It's a great story.
I mean, and now most of the probation departments in Oregon are called community justice. Whether they followed Denny's ideal or not, I don't know. But.
Yes.
I don't know what. Thank you. I don't know what relationship, whether this follows Jeremy's point or not, but I wanted to relate a recent experience. About a month ago, the City Council here in New York held a hearing on the subject of how to measure the effectiveness of public defense representation. Tina Luago and many of her colleagues from various public defender offices in New York testified. And I had a very small bit of testimony to give. It took until about 2 o'clock in the afternoon, so I had a chance to listen to several hours of testimony, which left me with an overwhelming impression, this might relate back to Sean's point as well, of a city that is over-policed, over-criminalized, in which all elements of the criminal justice system are just overwhelmed by sheer numbers. It's not just the public defenders who are. And then with the co-chair of that hearing was Councilman Rory Lansman, who I think is not from Brooklyn, I think he's Queens. But about 2 or 3 weeks after that, and 2 or 3 weeks ago, he wrote an op-ed in the Daily News that some of you probably have seen, or maybe not because it was in the Daily News. I got it because the court system sends out a press clips every day. And it was remarkable because it made a call for a dramatic reduction of arrests, which goes right to the bail issue, which goes right to the people being on probation and don't want to be there, aren't suited to be there. You can't do anything for them. They don't want to have you do anything for them. They just want to get out of the courtroom and out of the jail cell. I thought, I'm reminding myself that I need to send a letter to Councilman Lantzman for what I thought was a crystal clear indictment of current policing practices in the city of New York. I just thought that I wanted to put that into the mix because I think if you drill down from incarceration to probation to fines to short jail terms to restitution, you're drilling all the way back to arrests ultimately. And I can't believe that part of the reason that this country incarcerates 5 to 7 times as many people and supervises 5 to 7 times as many people and fails at, 9 times the rate that European countries do on the people we supervise, the over-inclusive number of people we supervise, has to be related in some way to the rate at which we arrest people. I'm not an academic. I don't know the rate at which we arrest people versus European rates and so on, but something's wrong in Denmark, I would say, and I thought Lantzman's op-ed was really a terrific window in that.
We've got about a half an hour left, so 3 things very quickly. One, is there anyone who has not had a chance to speak up yet who would like to? Yes, please.
Right now?
Yes.
So I study criminal justice debt, and I've heard a lot of mention of fines, restitution, bail, there's probation fees in New York. She just left. Where's Juanita go? I was going to say that I would caution against thinking of fines as yet another alternative sanction. I think that the effect of debt, that all of the issues that are raised about probation apply to all of the use of money in criminal justice. So what goal are you trying to achieve? What is the effect on people? I really appreciate what you said, Sean, about eventually we're just going to be talking about fines. I think that's true. I think we should just not talk about fines. I think we should pretty much take them off the table because fines are punitive. Restitution is entirely separate. Contract with the criminal justice system entails a myriad fees, surcharges, et cetera, et cetera. So if you are talking about an alternative to incarceration and you're trying to be punitive, then it entails understanding that people have already been punished with money by the time they get to incarceration to a significant extent. And the article does mention day fines in Europe, which takes into account people's ability to pay and the severity of the offense, which is all fine and good, but as we all know, disenfranchised and impoverished people are not going to qualify for that, right? So we should, I urge to just kind of not think of fines as yet another alternative sanction, and actually subject the use of money throughout the criminal justice system to even greater scrutiny than we have done so far.
Thank you. Yes.
Well, I'd like to say that I think that I've been doing this work a long time. And I have a 20%, 60%, 20% rule. The top 20% are people that get on probation that I don't care what we do, we're never going to help. I'm sorry to say that, but there are 20% of the people that we just can't, we're not going to be able to help. There are 20% on the bottom that never should have been put on probation in the first place because they don't need us. They, with a little slap on the hand, we'll never see them again in the system. And then there's really the 60% that we should be concentrating on. That's really where we should be putting our resources. I think that there aren't, a lot of people dictate what we do in probation. We have state rules in New York. Someone else tells us how to supervise, when to supervise, how many contacts to have, how much money we're going to get for doing that. We have no mandated, the things that are important to us, mandated caseloads, we don't have any of those. So you could have a caseload of 250. Your tolerance with violations of probation, even technical violations, I say would soar when you're supervising that many people. You just can't put the time and effort into doing a good job. So our tolerance becomes less. We definitely put too many conditions on people. If we have any control over something in probation, it may be that. But then again, we don't really have much control over all the boutique courts that are being set up. So every new court that comes in, you have all new conditions with that. So you got domestic violence. Now you have domestic violence conditions. You have sex offenders. You got sex offender conditions. You got drug court. You have drug court conditions. We've got veterans. We're probably going to have veterans conditions. So the more courts we create, we don't create them. The state of New York creates through OCA. Then each court then has their another whole layer of conditions that we have to try to enforce on behalf of the court. So there's something inherently wrong with that. And I totally agree with the article. I think that we put way too many conditions on people. If sometimes I think we do it, I hear officers say, well, you know, I don't need that condition today, but I might need it next year. So maybe drinking is not a problem today, but you know, it could be. And you know, I won't ever be able to go back to court and get that condition, so let's put them all on now. So we put 50, I mean, sex offenders, I think they got 56 conditions. Holy God, I mean, realistically, do we expect them to fail? Yep. Because 1 out of 50, I mean, they're going to violate at least 1 out of 50. So we have to have this whole, I think, new thought process about technical violation, because in most cases, that's what they are. They're technical violations. So I think that may be something, if we didn't have all the specialty courts, that we may be able to start controlling ourselves within probation when we look at the conditions of probation that we're recommending to the court.
Right, and to be clear for the people in the room, Francine, in New York, who decides what the conditions are?
Well,
some are specified by statute.
Yes.
And the rest are set by the judge at time of sentencing.
Yes.
Right? And the probation officer has limited ability to add or remove. They have to go back to the judge to change.
To modify. If there's an upward revision, you have to go back to the court. If there's a downward modification, the defendant doesn't have to go, he just has to ask the court for the downward modification.
May I ask a question for clarification? When someone is in one of the specialty courts, he or she is also on probation, is that right? Or does that depend on where you are?
In most jurisdictions, yes.
Probation, and in some places, probation is not involved. It's in a pretrial basis.
Yes.
But everything that's not pretrial, they're under general probation.
Kathleen?
Yes. This has been a great conversation, and I've really agreed with almost everything that I've heard. But when we talk about the criminal justice system, one thing that seems more and more clear to me is that it's really not a system. That it's a series of intersecting systems. We have the probation system, we have the judicial system, the court system, the defense bar, the prosecutors, the police system. And I don't want to say they overlap, I think they more intersect. And by focusing on one part of that system or one circle, that we're missing the mark and we're not going to be successful. Is that we really need to look at how the various players interact with each other and impose certain limitations and certain restrictions on each other. You know, I think Rocco's point about the negotiated pleas is an excellent one. I've been advocating in Rockland County to use more pre-pleas so that we can inform the courts and inform the process a little bit more. But they're very, very reluctant to do that. The defense bar is reluctant to do that because we might illuminate some things that they may not want the court to be aware of. And it's not necessarily timely. So these are some of the issues. We have to deal with whoever is placed on probation. We can't have a waiting list. So we have to take them regardless of what our caseload sizes are. And you're right, and we prioritize that way. I'm really disturbed when I hear about the abuse of the control that probation has, because certainly that's a very, very real risk, but I would hate to condemn a whole system because of a few bad actors, and I think that falls on the probation administrators to ensure that if we become aware that is going on, or that we address that. And probation officers, as much as probationers, need to be held accountable. And that should not be tolerated. So to eliminate the system or to not use a resource because there's a potential for abuse, I think is the wrong, kind of the wrong message to put out there.
I just want to make sure there's nobody left who has not yet had a chance to say something who would like to. Yes.
So thank you to Marty for bringing me into this, and I had a chance to sit with Ron this morning and talk a little bit. Wanted to thank Ravina as well, because this was an issue back in law school in Boston that we had talked a lot about, the opportunity to put representation in probation revocation hearings and things. So great work in assembling this 20-state survey, and I think that first alpha stage, as you define it in some of the materials there, of understanding what the offices are doing, how probation varies from state to state, from county to county, and sometimes from one officer to the next is a really important piece. And being from Massachusetts, I think I have probably an unhealthy obsession with the Willie Horton effect. And I'm wondering, when folks switch to the beta version and you agree, you embark on this change of course that you're willing to go into, are there things that you want to make sure you have in place to provide some political cover when something does go wrong? Are there ways that we can structure that second phase where we set up things to change, where we can capture some information, either we have things in the queue, that we can provide some protection for those that are willing to after looking at that hard data, to make some change and take a risk. And one of the things that really put this back on the map for me is that in the Times today, there was an article about looking at de Blasio's call for decrease in arrests of marijuana, possession of marijuana, and that they were finding a decrease in murders connected to marijuana sales in the city. And so that connectivity of violence to drugs persists, and that there's kind of a flash in the pan, and does all the great work earlier on kind of go the wayside once there's a danger of political consequences.
I read the same article this morning, and I was surprised that that reference was made in we're 2 months into the year. There are plenty of homicides. If you could connect one or two that maybe weren't there last year, that anomaly from one year to the next, about how quickly we connect murders to marijuana sort of jumped at me pretty quickly. It didn't make any sense at all. And there's a couple of things. There was a comment about, when probation does the probation reports, and they did when I was there, is that there's no, and you talk about political cover, there's no reason to recommend less, because less is risky. If you put in the report that this person should probably not even be on probation, and a week later the person commits a crime, everybody's going to throw whoever wrote that report under the bus. You can count that in a heartbeat. So there's never a reason to go less. There's always a safe reason to say yes. And the other way around, if you recommend more, and the judge says, nah, I'm going to ignore it, in many cases, and I've seen that happen, the probation officer is the first one to leak the press. I told them to do more, and so there's no reason to do less. So that's why, if anything, reports of that type should be done independently, if anything, of the systems who are going to deal with it. It has to be an independent, because the reason I think with probation and parole officers always in a catch-22 is that whenever they take the path that would seem like you want to work with the client, and at the end of the day the person violates, they immediately find themselves defending themselves and reading about themselves in the newspaper. So that's the risk of all of that. The decision, if the mayor makes the decision, which I think was the right one, I don't think he went far enough, that to look at the whole marijuana issue in a different way, he won't get credit for the benefit. He'll only get credit the first time somebody connects the two together. Whether in the long run, a year or two from now, that's not going to have any connection, because this is a speculative time frame. It doesn't make any difference politically. It's always better to risk the air of incarcerating, tightening up the rules. There's no benefit and for anybody individually. It only can be done by systems. System covers.
large systems cover each other, to protect each other, to make that the call for the long haul, not for the short haul, for the long haul.
Who would benefit most from probation? Critical. What is the next question? What conditions are appropriate for me to expect and to include? And of course, how long? So those are always reporters' questions, but I'll make them judges' questions as suggested. But I want to talk about one more thing. We, as the judge, agree on the disposition with the attorney and the prosecutor, and then probation gives us the pre-sentence report. And as noted, the decisions are already made. Perhaps we might reinvigorate what used to be the pre-pleading investigation for the purpose of having best practices, or what I'm going to call an informed use, to determine precisely what those conditions and what the length of probation would be. And I don't know where that dialogue would take us, but certainly in New York, I have the option of shorter probation terms, and that was passed recently. So I did want to throw that out on the floor.
I'm not going to forget Peggy, but I think we've got a quick
Just
response.
a quick thing that made me completely crazy, what I call the fill-in-the-blank probation reports, which were instituted some years ago. And it did.
The Sherry did.
Actually, the Sherry. How many clients have I had with how many probation? Who wants to plead
I
guilty to that
eliminated
one?
them. There were no blanks. I didn't think.
You just eliminated them altogether.
The fill in the blanks is an improvement over here.
I remember probation reports from 1975 told me everything I ever wanted to know about that probationer, his parents, when his grandparents were in Ellis Island. And then we got a piece of paper that said, does it have a name? Maybe, you know.
Resources.
And that was because everything was pre-arranged. You can laugh now, guys. See, you reap what you sow. And then we wanted to do pre-pleading report. We don't have any money for that. We have to get a statute change, right? Judge Newton, we're not doing that. There's nothing in it. I said, I have the gavel. And they're helpful. So what goes around, we've gone full circle, and we know that the more that probation can let us know, particularly if there's a possibility of probation, the better it is. And you just have to say mea culpa.
Well, I'll take the mea culpa,
Okay,
Judge.
all right, good.
But I think,
It's money. It's a money issue. I understand.
Well, no, it's more than a money issue.
Yeah.
It's more than a money issue, and I know that I have support in the room. The reality is, and I'll put it on Tina, I'll put it on Judge Alvarado, I've put it on prosecutors. When I said to judges, we would happily write that 1975 pre-plea investigation. Everybody said, you'll gum up the works. We don't have time. The defense didn't want the judge to know everything at the time. Because remember, in a probation report in New York, we can delve into the juvenile record, which you don't know when you're taking the plea.
Okay, Marty, I defer to two judges. I'm not going to defer too much longer.
I'm just saying that the reason is, and it gets to the point about bail and about pleas. The deal is done. The probation, the pre-sentence investigation, at least in New York City, maybe elsewhere in the state, is an irrelevant document. Judges have said, don't bother me with it. Judges have told us, we don't want your recommendation. We don't want your recommendation. And the defense has said, we don't want the judge to see all that. And the prosecutors have said, we have to move our docket, and it'll just slow things down. So why not fill in the blanks? Peggy?
Peggy, after you, I'll go after you.
Oh, is that
Peggy,
Cecilia?
Rocco,
Cecilia? Okay. Who wasn't you, Cecilia, then I'm not. So I'm not going to respond directly to Cecilia's paper because I've actually had the pleasure of doing that before. I think it's wonderful and covers amazing ground, but she knows that. I wanted to respond to a bunch of things that have been mentioned, and I wanted to start with Jeremy and Anna's sort of utopian justice system, seceding state. There are actually many rural areas in this country that are doing exactly what you're talking about because they can, and this goes to Marty's point about gumming up the works. They don't have works to gum up. one another. They're experimenting and trying a really fundamental kind of community justice that seems unthinkable in the Bronx. And in many large cities, Albany, Rochester. So I think we ought to be looking for some of those and finding them and figuring out are there ways we could reproduce them at least for some people in some circumstances. And I know probation has, in New York City, has experimented with place-based probation, which has the possibility of doing more of that. But this is not, certainly not to toot my own horn, it's just I had the privilege of spending a couple of years traveling around very rural communities and documenting what we saw and writing about it. And it seems like another world to me when I listen to people in large urban areas. So I just wanted to say that it is possible, people are doing it. The second thing, to go back to the hope thing with Gannon, I'm sorry Sean is gone. What I neglected to say was that judge was only dealing with very high-risk probationers, the people that were put on probation because the judge took a chance. He took a chance. And I think it's important to remember that. And going with that back to the swift and certain, I think the emerging jail research on even what 72 hours in detention does to people in terms of the things we care about, in terms of public safety, in terms of their lives, we have to keep that in mind if we're thinking about using swift and certain. And I think when we think about how is probation, how can it be used usefully, when someone has a job or someone is going to school and we mess with that, either by 2 or 3 days of detention or by making them do all these other things that Cecilia has documented and that most of us have seen, we're making probation a failure. Because those people, in research that there is done on New York State parole cases, the more people were engaged in any kind of activity, it didn't matter what it was. Even if they were just told to go to alcohol treatment and they didn't really need it, anything that kept them occupied was the best predictor of success on supervision. And it, as I said, it didn't matter. And so if people are engaged, we want to support them in being engaged instead of messing with them. I want to emphasize, I think what Mr. Leahy said, I have a terrible desire to call him Patrick, but it's not him.
Okay, Maureen.
Yeah, no, I meant the senator. No, not the Irish name, I was thinking of the senator. I think we mess up terribly if we overlook the police and we overlook what they're doing. The system is as big as it is because of the police. And until we start looking at that and understanding the relation, how many people that's the other thing in local communities, how often the police just keep people out of the system who in the city would be arrested. And I think we also have to look at, supporting the police in the way that Jeff was just talking about the political, who has political cover. We need to support the police in doing more to divert people on the street. Not everything they've been even taken down to the precinct house, but diverting them on the street. And we need to give them the tools to do that, and we need to give them the support to do that, and the training to do that. And we don't right now. I'm not speaking about New York because I actually know, oddly enough, know less about New York than others. And finally, for the probation agencies, we talked about balance and we talked about, the right people. What are we doing in agencies in terms of designing job descriptions and screening of who we're hiring if we want this more balanced vision? And how are we rewarding the ones who do it? How are we rewarding, how are we promoting? How are we even if we can't give them more money, can we give them recognitions? We talk about giving probationers rewards for doing well, right? Maybe we give them a Metro card, or maybe we give them a Target gift card. We talk about positive reinforcement for probationers who are doing well, but what about the officers? What are we doing with them? How are we rewarding the ones that demonstrate the kind of behavior that we want to see in probation officers.
Thank you. We're heading down the stretch, and we've got Rocco and Anna.
All right, real quickly, just a couple observations. Talking about quick and certain, we are anything but that in New York. We are very slow and very confused. I can't see how we handle the violations, really. And I can speak from a 25-year history of that. But taking a leap of faith, that at some point in time, we are able to get the length of probation sentences under control, which I think we are. We now have new laws that allow flexibility to determine the length of probation sentences, where we used to be tied into exact time periods. And if we can get conditions that are appropriate for individual cases, and we just don't boilerplate conditions and just check them off because we think at some point in time, as Brandon said, we're going to need them down the road. One of the things I think we need to do in the system is to make sure that when we file violations of probation, especially for technicals, we better make sure that we've done everything we could have done. And I think most of our probation officers do this before they file for a violation, especially on a technical, to make sure that we've done everything as a profession to avoid getting that case into court. Because my feeling is, if we are going into court, we should have exhausted every means available to us to try to put that person back on the road to doing the right thing. And when we bring a case in before a judge who is already extremely busy with a workload, that we're going in there for a good reason, that we've exhausted every means and maybe it's time for judicial intervention. I think that's the way the system should be.
Thank you, Rocco. Anna?
The PSIs thing is like a whole other meeting.
But it's critical because
No, but I was
it's
just
about
gonna
who
say,
gets probation
right.
and why.
It's also, so again, back to the lens, the values, whatever. So right now, I think if we were to summarize or to categorize what we use as a system, PSIs, for, the Department of Probation makes a recommendation as to what the defendant deserves, usually. I think that's the, if I were to sort of generalize what we're doing. And what if we then change the approach to a report that doesn't make a recommendation, and I try to get out of making a recommendation, but I'm not allowed by law, and just talk about what are the conditions under which this person could stay safely in the community, and can those conditions be met? And if they can't be met, that doesn't mean that incarceration is the answer. It means that we have to look either somewhere else, or maybe yes, incarceration could be, but we don't make a judgment on that. We just assess what are the risks, back to the R&R that somebody mentioned before, the risk needs assessment and the risk needs responsivity stuff. What does this person need to have in the community to be able to thrive and to be able to get out of the system, rather than what do they deserve as a punishment, right? So we start thinking that way. Maybe the PSIs become more relevant even at that stage, even if we can't move them up the stream. Because the issue with moving them up the stream also is that you want to ask the person to reflect on what they've just been convicted of, or what has happened. And you can't do that for a PPI, for pre-plea. And so, so it's a little tricky that way. It's a mixed bag in my view, although I would rather have it be more meaningful as a report. And as to your point, in terms of probation officers, I'm dying to find the right the right mix of incentives and rewards for people who are doing the work that we're doing. We're in the process of revising our tasking standards to reflect what we want, right? Through that approach of engagement, making sure that infuse it in our version of CompStat, so that comes out, and it's all a parallel process. We need to work with our officers and our staff the same way that we want them to work with our clients, and so therefore we have to find those ways. Given that we can't pay people more money necessarily, I think it behooves us to find that.
We hope the conversation can continue for a little bit over coffee. But at this point, I think we will formally adjourn. But before we do that, the last word goes to Kevin. Last words go to Kevin and Jeremy.
Well, thank you so much, everyone in the room, for giving several hours of your time to be here. And the hidden purpose of this meeting was for us to come here and be educated by you, and I think that's been fulfilled, and hopefully many of us will stay in touch. I just wanted to mention a couple ideas that have popped into my head during the conversation that strikes me are areas in which New York is probably ahead of the curve in comparison with the rest of the country, but I doubt that any jurisdiction is really where it should be. We've heard a lot of discussion today about probation populations, and I tend to think of this as an overcrowding problem. Much as we have a prison overcrowding problem in this country, we have a probation overcrowding problem as well, which makes one's mind go in the direction of population controls. We don't have really robust back-end population controls for probation. And it seems to me some of this is pure Ron Corbett, some of this is going to be Kevin Wright, some of this is Cecilia Klingel, but it seems to me that if you had a standard probation contract, that no matter what the maximum term of supervision is, there's a presumption that after 1 year or 18 months, you pick the timeline, of substantial compliance with conditions, the absence of a serious violation, that you will be given early termination. And this is a commitment that's made up front. It would be best if that were the default rule. Judge doesn't have to get involved. The early termination is going to occur unless something else happens in between. It's the probation department's discretion to identify the cases where that isn't appropriate. And similarly, and this is going out on more of a limb, Cecilia and I worked together on a redraft are working together on a redraft of the Model Penal Code as it applies to sentencing and corrections. And one idea we floated, and I don't know whether it will actually float or sink, is that we ought to have some kind of an emergency power to respond to overcrowding in community supervision populations. I don't think anyone believes that the courts will get involved and will ever hold that caseloads that are too high violate the Constitution. We have constitutional litigation in prisons, but we're not going to have the constitutional spur in community supervision, and yet the problem is more acute because we have this huge explosion in populations and resources have not kept up. So one of the central problems for community supervision is to prioritize and reallocate resources so they're not being frittered away wastefully, but are being concentrated on where they're most needed. So I would like to see, and it's hard to design exactly a trigger in terms of maximum caseloads depending on supervision levels for a given department, and some sort of oversight where if an agency is overwhelmed and overcrowded, that there be some early release mechanism that would be more muscular than usually in place to be culling your populations of the least needy of probationers, terminating others early. It's much as we have had in the past, either through litigation or sometimes through statutes, emergency release practices for prisons and jails. Now, as I say, this idea goes out on a limb. We've floated it within the corrections profession. We've been hearing more answers of yes, this is a promising idea, let's talk about it, than absolutely no, it's stupid. But both of these things I've just mentioned are ways of introducing a back-end control, an early release type of mentality to probation populations that would probably require legislation or judicial action, but that would give ultimately I would like to see an administrative power to terminate early, an administrative power to invoke and trigger an early release sort of emergency overcrowding response. Because if we neglect those possible areas of decision making and instead focus on the judge in the front end, then I think we're missing some of where we could be addressing this problem. The other thing I'll just mention more briefly is that as the Robin Institute works around the country, the problem of criminal justice debt and economic sanctions is one that has really hit us in the face more forcefully than we expected, more in some places than others. We work in some jurisdictions where the probation department's annual budget is 50% or 60% made up of supervision fees that they're getting from their probationers. But everywhere in the country, we see the overuse of financial sanctions, fees, costs, surcharges. And one idea we have put into the model penal code that has now actually passed and is now part of the new model penal code is that no financial sanction of any type, including restitution, may be ordered unless the court is satisfied that after payment of the sanction, the offender still has left over enough resources for reasonable financial support for himself, herself, and any dependents. A much higher standard, we hope, than the ability to pay standard that comes out of constitutional law. And we see this as a public safety issue. 50 years ago, the Crime Commission, Lyndon Johnson's Crime Commission, said one of the most memorable bumper stickers that came out of that effort was that warring on poverty is warring on crime, and that wasn't controversial in those days. We have ramped up so much the financial hardship that we impose on convicted offenders that it seems now that our policy is to exacerbate poverty, that we're using the criminal justice system to make poverty worse. Couldn't be more going in the opposite direction from the warring on poverty mentality of the 1960s. And we believe, without hard evidence admittedly, but we believe this is a public safety issue. You want people to get back on their feet. You want people to find jobs and have satisfying lives and be able to participate in support of their family. And that's what everyone wants. And yet the financial part of the picture has, just taking that apart, has gotten much worse in the last 15, 20 years and pushing in exactly the wrong direction. So those are just two ideas I thought I would mention to the audience before we close that are maybe on the scale of incremental ideas as opposed to the sort of big paradigm shift ideas we've been talking about at some points during the afternoon. But incremental changes that would be large incremental changes, medium to large size, as opposed to just chipping away at the edges of important problems.
Jeremy, you get the last word. Thank you. So let me thank our friends and colleagues from the Robin Institute for bringing this conversation to us today. It's been very, very lively, enriching, thought-provoking, and listening to my colleagues by the table, productive in terms of some of the things that people will take away from the discussion, and that's just a good thing. That's what I think all of us who care about these issues, and particularly those of us in academic institutions, hope that we can say at the end of the day is that we've contributed to the policy discourse in new ways. So I'm going to sort of come at some closing comments, and if you'll just allow me to do this by referencing the National Academy report on incarceration rates in the U.S. because I think it informs some of the work that we did there is remarkably, the crosswalk is pretty direct between that work and this work. And the first observation just to bring into this discussion, and Kevin reminded us that mass incarceration really is shadowed by or paralleled by mass supervision, policing practices, jail. So these processes are related to each other, and are responding in similar ways to things in our country, our culture. So what is the big thing going on that has brought us to this point? The fourfold per capita increase in incarceration, increases in supervision, and capital sanctions being extended further than ever before. So it's a political question. So why are we here? This is a deep, I think, a deep question about our culture, our society. We have, I think, in 3 weeks, Tina's working on it, but we have a interdisciplinary roundtable that we're hosting here on punitiveness in America. Why is America so punitive? And the first thing we have to remember is that it's not always been so. For 50 years, 1920, 1972, we had European-level incarceration rates. And then 1972, every year until 2009, they went up. So something has happened, something profound has happened over the last 40 years within our country, our culture, that has left us more punitive than ever before. So the conversation we've had about, well, it's not just probation, it's actual police, it's the prosecutors, and it's this, then it's drug testing, all these things are true because that is what our political environment now allows. So we don't have high incarceration rates because we have high crime rates, just the opposite. We have low crime rates and still have high incarceration rates. Why? Because we are much more punitive than ever before. We put people in prison who are already in prison, we hold them in prison longer. Life without parole, 3 strikes, truth in sentencing, you name it, in prison longer. And we put people in prison with mandatory minimum sentences who never been put in prison before, would otherwise have been on probation. And we've launched a war on drugs. Those 3 things, National Academy Report, those 3 things are what's driven the incarceration rate. Now you can go behind those and say, what is the role that politics plays? What's the role that race plays? What's the role that changes in our society plays? But those are the 3 proximate drivers. Those are all choices that we have made as our society through our legislative branches of government. So the most bracing finding of the National Academy Report is we are here because we chose to be here. We have mass incarceration because we wanted it. That's thinking, right? So that's a political question. So we have to think about what's the politics, what's the political strategy that gets us out of here. That's really where Michael was saying that's a high bar. What's a political strategy that gets us out of some of the things that we've been talking about here today? So the second observation that also comes from the National Academy Report is, and I love referring to it, because it's my favorite chapter in the book, chapter 12, the chapter on values, is to remind us, and particularly those of us who went to law school, we've gotten a lot of these lessons, remind us that there were principles, there were jurisprudential principles, there were social value principles that were intended to operate as a constraint on the power of the state. And they lost their power over this 40-year period. So this big sort of punitive impulse, fueled by the tough on crime politics, born in the 60s and the 70s when the country was sort of in upheaval, fueled by the racialization of crime, those principles lost their power. So I refer to them because I think they're important to bring into the probation conversation as well. The first one is proportionality. Basically, particularly the deprivation of liberty has to relate somehow to the crime. So Anna says, let's go back to what actually happened. It's not just because somebody needs something that we put those conditions on that you're talking about. It's not just because they need whatever. There has to be some relationship to what they're convicted of, right? It can't be a conviction, therefore we can do anything. So that proportionality principle, punishment fits the crime, applies really strongly to probation. So our rule was saying, are we law enforcement officer or are we social worker? That tension is also bounded by the limitation on probation's ability to do anything under either of those roles. And that limitation somehow has to be limited by the principle of proportionality. The second limit in chapter 12 of the book is my favorite, is the principle of parsimony. The principle of parsimony, much more powerful in Europe than here, but we have it ourselves. It's the least restrictive alternative from the model penal code. That you can't go beyond, the state can't do more than that which is necessary to achieve a legitimate purpose. So you can't impose pain we, in our name, more than that to achieve a legitimate purpose. So that applies really powerfully to probation. Right? You can't continue doing, which is imposing some sort of pain as a restriction on autonomy. Beyond that required, then it becomes just, then it's just punishment, right? So to what extent is probation the punisher as opposed to the one carrying out what the judge has ordered its appropriate punishment? The third principle that, and Cecilia really raised these issues at the beginning with her talk about autonomy and individual sort of freedom, is the notion of citizenship. So that there should be, in particular prison, but I think in any criminal sanctioning enterprise, some recognition of the autonomy of the individual, the dignity of the individual, the citizenship of the individual. The way we framed it in the Academy report was to say that we should never do anything that diminishes the power of the person to regain their rightful place in society, right? To diminish that power permanently. Prison is harmful by definition, but we should try to do the least harmful to their autonomy, citizenship, both while they're in, which has a lot to do about conditions of confinement, but after they leave this. So how do we also imagine the end of probation? How do we imagine a celebration that you finish probation? I always like those parole offices that would graduate from somebody from parole and say, and here's your voting ID again, or some sort of. That's why I love drug courts. A ceremony, it's done. Congratulations, right? So you restore somebody to status. If you look at the entire apparatus here as a diminution of status, the question is how do we restore somebody to status? And how do we ensure that we're moving toward that time all the time? So I think there's a great way in which the citizenship principle plays out here. And then the fourth principle in Chapter 12 is the social justice principle, which is that every public institution should be measured by us as citizens in terms of its ability to ensure that it does not add to social division, put it that way. Now, the racial components of the entire justice system fail by that measure. So we are adding to, and I think Kevin was right, we just continue to, it's not just poverty, it's racialized poverty. So can we think of a metric that asks whether what we've done in probation actually achieves a social justice purpose, and it gets close to Anna's vision, I think, of community justice. So have we done something that is actually value added, not to the individual, but to society? And then the final observation comes not from the Academy report, but from my favorite. We used to point to California always as a place where we don't want to do what they've done, but there's actually interesting stuff going on out there these days. And the most recent one is Proposition 47. So why is Proposition 47, in my view, really important? We had Lenora Anderson here twice now to talk about it at John Jay, most recently last week. So this is the proposition that reclassified crimes and felonies to misdemeanors, retroactive after court application, and will result in thousands of people being released from prison. So in this work, when we think about downsizing mass incarceration, you have to think about retroactivity. They've done it. By popular referendum, 60% of the vote voted for Proposition 47. So what's the political lesson, I think, from Proposition 47? The Californians for Safety and Justice, Lenore at the helm, with a big left-right coalition, got prosecutors, got libertarians, got the usual left-leaning folks to sign on. She started by talking to victims. The first thing that she did in building her campaign was to talk to victims and say, how is this working for you? How is it working for you that somebody gets sent away for 20 years and you're still suffering from PTSD? How is it working for you that your brother was murdered in this dark alley and the lights still don't work? Right? You really wanted that no one would ever be murdered there again, right? So they went and she organized a coalition of survivors who then became her lobbying arm in Sacramento. And the face of this campaign was victims. I think we underestimate the positive power of victims' voices. We have seen the harmful victims' voices, in particular California, where they were paid by the Corrections Officers Union to lobby for more prisons. But if you start with the notion that there's harm to be addressed, victims' voices are in some ways the most powerful reform voices. And then she organized around that, so much like the Brooklyn secession movement, organized use them to organize others to say, we can imagine a different way here. And I think there's something possible for that in probation. I really do. It may be, you know, much talk about out on a limb, Kevin. I'm not. I don't know where I'm inside cloud nine, maybe. but I think there's something possible here, and it goes back to, and maybe Peggy has the vision for us. It's the Benny Maloney idea that there's different ways of thinking about what this is the most nimble criminal justice capability available to us. And it's so interesting to sit here and feel how constrained it feels to you. And I just want to encourage you at the end of our time together to realize that you have a lot of power. And you have the power of being really close to community and really close to people who have done harm. And if you think about it, you can also be close to families and siblings and networks and even gangs. And there's a way to think about leveraging that proximity into power to reimagine what you do. And I wish you every bit of success.
Thank you, Jeremy. Thank you all for coming.